ನಾಗರಾಜ್ ಇದು ಆ ಶ್ರುತಿದು ಯಾವತ್ತಿದೆ ಕೇಸು GNWC
Lordship's kind leave, my lords. May I make a mention, my lords? I think your lordships are muted.
Just a moment. Is it in the list? Please wait.
Please,
Page wise, we'll call up.
please.
Any mentioning? List 1, page 1, seal number 1 and 2. Page 2, seal number 3 to 7.
Is listed today for hearing. When do you want it? Yes.
Page 3, 7 to 9.
Serial number?
All 2.
Yes.
Page 4, 10 to 13. Page 5, 14 to 16. Page 10, 17 and 18. Page 11, 19 and 20. Page 12, 21 to 25. Page 13, 26 to 32.
Sorry? Deposition.
59, 30. Next page.
30.
Page
30 is there. Page number.
Sir, page 12 ಅಲ್ಲಿ ಇದೀವಿ ನಾವು. Page 13. Page 14, 33 to 35.
Lords, serial number
Wait.
35.
Yes.
I appear for the appellant, my lords. Some
Are you hearing-
inconvenience for my senior today, my lords. May I request any date next week, my lords, or
Have you
subject to
informed the
lord?
other side?
Yes, my lords, yes.
This is a 2007 matter.
Lords, we were ready, my lords.
Listed-
There some personal inconvenience for my senior just today, my lords.
Listed from the warning list.
Yes, my lords. I'm aware, my lords. I'm sorry.
Listed on some near date, please.
Please.
Lordships kindly, serial number
Page
23,
15.
my lord.
36 and 37.
Just a
Also,
moment,
serial number
please.
33.
Just a moment, please. We'll come back to you.
Page 16, 38 and 39. Page 17, 40 to 43.
Twenty 21 petition, writ appeal. What is this about?
They had to file before the Mumbai court, and it is filed before the Nairobi court.
Listed on some near date. Yes. Please don't make submissions without informing the other side. The informing the other side has to come first.
7th,
7th, madam.
7 to page 18, 44 to 48.
And acquisition KID physics.
The-
Yes.
Next week.
Yes, any other submissions for adjournment?
Your Lordship.
Serial number 23.
What is this about?
13%.
13 is interlocutory application.
Yes, sir.
Please be here. Please be here.
Lord,
Yes,
serial number 23.
yes.
Would your lordship grant me a
23
week's
is
time?
in the
Because-
orders list.
Yes, my lord. The party has engaged a senior counsel. That senior counsel is busy in another case.
It is for orders, recall application.
That has already been
Recall
recalled, my lord.
It is
After
not.
we'll see that after the-
Yes,
Please, Lord.
please be here. Just a moment. We'll look at,
We'll see
it's
that.
an orders
Number
matter.
30.
Let's see the file. Yes,
Serial number 33, Your Lordship. 33.
is it for file hearing?
Just you wait.
No, Your Lordship. The notice was issued on the
Please-
previous day.
Please be here, please be here. Yes,
Please.
we'll call it. Yes,
List two, orders, serial number one, Anushriya.
The respondent statements.
I'm for the petitioner in this case.
yes, what is this?
This petition is in lieu of the matrimonial dispute between the petitioner and the respondent. So
How is the habeas corpus maintainable?
Yes.
this is because the father has taken away the child. And from last 8 months, we have no contact with the child, and we do not know where the whereabouts of the child are. Child is.
Have you
Yes,
filed
yeah,
before the family court?
they have filed a GNWC seeking for the custody of the child. And we have asked for the visitation rights also, and they have vacated the previous residence, that is a matrimonial house, and they have shifted to a different location. And also the school has been changed by respondent number 4. So we don't know where the child is, and we are not able to contact the respondent because he has blocked the mother on WhatsApp. So that is why we have come before
Just a
this
minute.
honorable court.
Nay. Could this-
Yes.
Lord, could this honorable court take away the
To
jurisdiction
make
of
it, to make it maintainable, the contention is that they don't know where the child is.
True, my lord, but that has to be complained before the court in which it is pending. No.
Unless the notice can be served in the,
Not for respondent number 4, my lord.
notice is served.
Notice they've come before the court. It's for hearing on the IA for visitation.
What do you say?
So they have not come before the court, and they are just adjourning the matter, and they are not hearing the matter. They are
And
not
it's for
appearing
7
also.
to 25 for hearing on the visitation.
It is not, it is 1/2/2025. That is the date of hearing. And they are not coming to the court and hearing the matter. And the mother is completely depressed because she is not able to see the child.
Counsel, that is not the question. How is a writ of habeas corpus maintainable for production of the child from the custody of the father? What is
Because we
maintainable
do-
would be a guardian in ward's application. You are aware of where the child is. Notice has
don't know.
been served.
We don't know because they have vacated the residence, that is a matrimonial house. They are no longer
Where do you
staying
say
in that
so?
house.
Where do you say so? Where do you say so in the writ petition?
We have mentioned that in the writ petition as well, because we don't know
Where
the
do you say so,
whereabouts.
please?
Yes. That is paragraph number 20.
Incorrect submission. That appears to be an incorrect submission. Let them file and leave it in the-
Paragraph number 20. 21. Currently, the petition has no idea where he is staying with the child and where the child is continuing his education.
You don't have any such case before the custody court.
We have filed for visitation rights, and they're not coming before the court to hear the matter. And he is not bringing the child, nor is he appearing personally before the court. Not even a single day after filing the case, he has come before the court along with the child. And that is why we have come before this honorable court.
All those are
seeking-
matters, all those are matters for you to take up in the family courts or guardians and wards jurisdiction, not in a writ petition under for habeas
My
corpus.
only submission is, Your Honor may kindly pass any orders asking the father to at least see the child, because we have no whereabouts, we don't know the whereabouts. Let him declare that
That is
he's
for the
staying in
family
so
court
and
to
so.
decide, counsel. What do you say?
My lord, they've already appeared. It's for hearing on the IA that they've filed for visitation.
They are not
We
coming
said
before the
1
court.
February. They've been
Please.
appeared. We've sought time for arguments.
They
That
are
is
only
on,
seeking
7
time
to
from
20.
last 3 months.
Counsel, please. This is a court.
So they very much, they are aware about the whereabouts of where we are. It's all mentioned in the petition.
Is the next date of-
It is
Seven
it is
to
not
Monday.
mentioned in the
Seven
petition
to-
for
Please
my
don't
lord,
interrupt counsel. We've heard
sorry,
you.
I'm sorry, sorry.
7 to 2020.
2020.
Please place your objections on record. Next week.
Speak, we're disposing. Whatever you wanted to say.
Hello?
Whatever you wanted to say.
Much obliged.
Please see that the objection is on record by the next date. Yes.
After 7th or before 7th?
Either way.
10th.
7th does not affect it. They have to place it on record, that is.
Okay.
Yes,
4-2.
4-2.
Much obliged.
2, Anup Harnelli.
Gunda Act detention, December 2024.
It is pending for 30 minutes.
The objections are on record?
Yes.
Pass over.
Number 3, MB Chandrachud.
30-year-old
I am for respondent number 5, my lords.
father.
The father is present.
Hmm.
The detainee is also present here, my lords.
We'll have it in chambers. Chambers at 1:15.
Please, yes.
This
He has to start with the time. Members 150.
The petitioner is here. She wants to, let them speak to each other. We'll have it at 1:15 in chambers.
Please.
If he wants to speak, if they want to speak to each other, let them. We won't stand in the way. Yes.
Bidepa. Just ascertain whether they want to talk to each other. or
Yes,
not.
yes.
Then we will allow it.
List 1, admission. Number 1, SV Prakash.
SFC Act.
Will appear for respond.
Personal guarantee invoked in 2002.
The past by district jail. And under section 31. Admitted. It's not admitted.
2017.
And my lord, your lordship, please to admit and post it my lord, to bear on my stay application. Admission, my lord, already admitted. Condone the delay. Your lordship.
Delay condoned, not
Condoning
found.
delay. There was small delay in the appeal. My lords, please to condone it.
Condoning the delay, not-
Order, you should deposit amount. May, as good as. But as far as my stay application is concerned, but the application may be called after 3-4 weeks. Reason is, but I have advised my client not to approach the branch manager of the corporation to see that whether there is any possibility of settlement, some scheme where in that. Therefore, after admitting, my lord, matter may be posted after.
Right.
We can list this after 4 weeks.
Not your lordship may, submissions may be placed on record, but that is, not, he says that not, there is a possibility of settlement, that may be recorded.
I have no objection. And make submission.
What is here, when counsel for the appellant submits that his client is intent to settle the matter with the corporation, said submission in place on record.
Please.
List after 4 weeks.
But admission may be.
It is admitted.
All parties here.
Number 2, Murugesh Charity.
Feedback upload. But matter do not have. And you could come back, they said that they are willing to make some payment. That's why you not.
The
insisted-
payment which was sought for by you, 21,27,477. That has already been paid.
No,
we- Not-
we took the
They're-
DD, but they did not
They're,
accept.
they're willing to pay it.
Yes. But
So now what remains?
no, nothing remains, bro. There's a interest portion which remains,
Hmm.
not which they'll have
He's
to pay.
willing to pay interest also at 10%,
The rules.
not
say
10%. He said the bank rates, that may be even higher.
the rules say I cannot come forward to accept it without there being violation of the rule. But may kindly take rule 13. What I have asked for is as per rule 13. I'm not asked anything more. May kindly
What
take-
does Rule 13 say?
Rule
Please read.
13 says what 21st.
Please read Rule
Yeah.
13.
Yeah.
On what amount is the interest payable?
Yes,
BDA rules.
yes, 1984 rules.
Rules. 1984 rules.
It was not a 836. I apologize.
Page number?
No, that was 360. 360.
Allotment of sites rules.
Yes,
Rule 13,
rule 13.
please. Yes, 360.
See,
Allotment of a site.
allotment, condition of allotment and sale of site.
Hmm.
The allotment and allotment of a site under these rules shall be subject to the following conditions.
Hmm.
What is shall, within a period of 60 days from the date of receipt of the notice of allotment, pay to the authority the balance title value deducting the initial deposit. If the balance title value is not paid within a period of 60 days, the authority may, on an application of the allotee, extend the time for a payment of further period not exceeding 120 days as a final term, and allotee shall pay an additional interest at the rate of 18% on the balance title value for the first 30 days, of the extended period, and the rate of 21% for the next 90 days of the extended period. This honorable court, since they asked to agree for, the act said, come out with what is the exact value that he has to pay.
First, your rejection when you have made the difference amount, whether you have referred this rule.
Yes, this is only on that rule, rule 11.
No,
may
please tell us when was the alternate site offered to him?
Lordship, kindly, may I, from the beginning, I'll give the dates, but the dates may be relevant.
Dates, the first dates are allotted on 26/7/2007.
Yes, page 27.
Then alternate site,
Yes, Lordship, kindly mark this becomes a little important. Lease cum sale agreement was entered into on 8/10/2007.
hmm,
8/10/2007.
in respect of the
Earlier.
of site number 276 of the HBR layout.
Yes.
Huh.
Then he goes on paying from 2007 up to 2011.
Hmm.
He pays taxes for the property.
Hmm.
He is in possession of the property.
Hmm.
Kindly take rule 11. Rule
No,
11.
that is not the question.
But
Now-
may I make this?
Hmm.
Why it becomes relevant? But he is not a general allotee. He is an allotee based on a G category because he was a member of the Legislative Assembly. And Lord, he was given a site, not as a general allotee. That doesn't make a difference what he is. But the fact that he was given possession of the property, he accepts possession of the property, he stays in the property. Not rule 11A, yes, Lord, it makes a lot of difference for us. Rule 11A, as an alternate site can be given to only those people to whom the BDA is unable to give possession of the property. Here is a question of.
That is-
You are arguing all these.
Lord, it was out
There's-
of turn benefit extended to him. Out of turn benefit extended to him. Lord, may kindly see. And that too, from HBR layout to a previous layout in a RMB second stage layout, one of the best layouts, previous layouts. It has to be given in a subsequent layout. All rules were flouted.
Why you have given them?
Not He
Who
is-
is floated? You are floated.
that is
Council,
the-
on, just a moment, please. On 26/2/2022,
Yes.
there is a allotment of the alternate site.
The,
26/2/2020, I'm sorry.
yes, like 25 to
When-
20
yes.
25 to 2020,
That is the,
page 73.
allotment of the alternate site.
Yes.
It is on 4/6/2020 that you, 4/6/2020,
Yes.
that you call upon him. This is not, nothing, none of this is done by him. It's by you.
Kindly-
4/6/2020, you call upon him to pay the balance value of 21,27,477. Correct?
Kindly take my alternate allotment. Page 73 may be taken.
Hmm. Annexure H.
Yes.
Hmm.
This is 25 to 2020.
Hmm.
Then I call upon him to make the difference payment.
This only says, difference payment is 4,000. Alternate site fee,
No,
That is all.
alternate side, that is 4,000 is a charges.
site fee. Therefore, it is only on 4/6/2020
That is
by a separate, communication that you require him to pay the balance.
4,000. That is charged.
Whatever that be, council. You only ask him on 25/2, you only tell him 4,000. Then on 4/6/2020, you require him to pay the difference. That is
As per rule,
21,27,477. Where is that?
that is, not the
Page number?
page number, not
Annexure K.
yes. Yes, page 77 is 79, 77, no, 78.
Translated 80.
Yes.
After remitting the areas of cital value in respect of site bearing number 18, I will say 21,27,477. Yes, this is on 4/6/20.
Yes, this is also as per rule 11. Lord, Lakshmi, kindly take the rules. Lord. I shall show as to how
Hmm.
I have asked. Rule 11.
Hmm.
Rule 11A
Hmm.
on previous page.
Hmm.
Allotment of an alternate site
Hmm.
where the authority is unable to hand over the possession of the site allotted to
Hmm.
allotted under these rules to any allotee due to a stay orders of the court or any of the other reasons, the authority may allot an alternate site to such an allotee subject to following conditions.
Hmm.
Doctor, kindly take this just to our part. Four, while allotting an alternate site, bigger it site, than the site originally allotted shall not be considered for allotment. However, alternative site, 10% over and above the area originally allotted site may be allotted, and in such cases, for extra site area, what additional site value applicable to that layout for the site shall be collected by the authority in addition to the difference in cital value to be collected. In addition to difference in cital value.
However, an alternate site up to 10% over and above the area of origin may be allotted. In such cases, for the extra cital value involved, additional cital value, absolutely. So all that is not under dispute.
But this is in addition to the title value. What was the title value in HBR was lesser. And the value of the site in.
Well, that is not in dispute. Now you have, by the order dated 25/2, required him to, allotted him. It is not him. He has not passed any order. You have passed the order,
Yes.
making an alternate site available
Yes.
and asking him to pay the difference.
Yes,
Therefore, that difference he is prepared to pay.
he is prepared.
Yes.
Yes. But that he is not said. In the appeal, he is saying.
No, he has filed a
And
memo.
one more
He's filed a memo saying he's
Memo and demand
prepared to
draft was
pay.
also sent, it was sent back to him.
note with
Now,
the-
is it on account of any fault of his that there was delay? He gives you the draft. He says it is not accepted.
Sometimes he challenges-
When?
he
That,
challenges-
yes, yes. So when did he make available the demand draft for the amount?
DD during the pendency of the present appeal after the matter was heard, when the matter was to be decided, that is when they made a memo saying that we are ready to make that payment.
Hmm.
But at least till then, at least till that point of time, your lordship may levy one aspect. The second aspect, the learned single judge has directed us to execute sale deed. Lordship may kindly take that. But he becomes an allotee. But he has to fulfill certain conditions. There has to be a leave come sale agreement. May I request for modification of that? But why it is done only with an intention to see that the allotee who gets allotted puts up a construction. Rule 11 also prescribes as to what he has to do. He has to put up construction within 3 years. Not if I now execute a sale deed, not he will sell it off. He may sell it off. Sorry, he may sell it off. That is why a condition is there that a lease come sale agreement has to be entered first.
Which is the condition?
Rule 11.
Rule 11.
Yes. Sorry, rule 13 only. But skip the first rule 13(1) may be one, 13(2) may be taken. After payment under sub-rule 1 is made, the authority shall call upon the allotee to execute a lease come sale agreement in form 3. If the allotee fails to execute the lease come sale agreement within 60 days after the authority has called upon him to execute such an agreement, the registration fee paid by the allotee may be forfeited and the allotment of the site cancelled. And the amount paid by the allotee may be refunded by the authority after deducting such expenditure as might have been incurred by the authority. Lord, then I'll skip Lord. Lakshmi will take sub-rule 5. Until the site is conveyed to the allotee, the amount paid by the allotee for the purchase of the site shall be held as an authority as a security deposit for the due performance of the terms and conditions of the allotment and the lease come sale agreement entered into between the authority and the allotee. The allotee shall comply with the conditions of the agreement executed by him and the building and the other bylaws of the authority or the conservation as the case time being. The allotee shall construct the building within a period of 5 years from the date of execution of the agreement or such extended period as the authority may in any specified case by a written order permit. If the building is not constructed within the said period, the allotment may be after reasonable notice to the allotee cancelled, the agreement revoked, the lease determined, and the allotee evicted from the site by the authority and
Special allotment.
it has to be a lease come sale agreement, not sale deed is my respect.
Yes,
Then it.
we'll consider. Yes, please.
There was a inquiry because of a PAL. So for about 3 to 4 years, nothing happened. After the inquiry, my allotment was cleared by the committee. I approached them. I visited the site. The site as such, the number given as such was not in existence.
Never mind. All that is past. Now, after the reallotment.
Was not in existence. Then I pointed out the site which you have given as the number so and so is not in existence. They sent a engineer for inquiry of that. Either there was some modification of the plan or the site as given was a non-existent site that is available in their note dated 6/12/2019.
No, we are not going behind the reallotment. The reallotment happens on 25/2/2020. That is a reallotment.
Please.
On 4/6/2020, you are called upon to pay the balance price. That you challenge. The learned single judge says it has to be paid. So now.
No, learned single judge said he allowed my petition. The difference need not be paid is
I'm sorry. Yes.
Need not be paid was the. And the matter had come up for hearing on an earlier occasion. I think His Lordship Justice Vijay Kumar was a member of that bench. It was suggested, why go on arguing whether site was in existence, etc. Why don't you pay the amount? Absolutely. I said I will pay the amount, and I took the DD and approached them.
Yes, when did you take the DDL approach?
First, when we.
Hmm.
First, or return on the application. Application.
12/9/2023 is the DD date.
12/9 ಅಲ್ಲ ಇದು ಅದಕ್ಕಿಂತ ಮೊದಲೇ
Yes.
ಅವ್ರು ತಗೊಳ್ಳಿಲ್ಲ ಅಂತ ಅರ್ಜಿ ಹಾಕಿದ್ರು.
It was a case where the repetition is allowed. And it is only because of that. Yes.
12/2023, he submits a representation along with the DD. 26/12/2023,
What is the date of the judgment in the writ petition where it was quashed?
Please,
18/12/2020. When was the appeal filed?
17/4/2021.
With delay. 17/4/21.
He was taken in 2023.
Only from 21 to 23.
26/12/2023 is the representation.
What till the date when he took the DD? He was before. They did not
Yes,
accept.
And also
Absolutely.
from the date of
Absolutely.
their demand.
Therefore, 17/4/2021 is the earliest date. Or? This is not payable because it is on offer.
Because of their fault also. Demand they make, it is not paid, then the price applies.
Correct, correct, correct.
Here it is not a case. Even in the first allotment, they are not issued endorsement.
it was on 26/12/2023.
Just a moment.
Not this. Other
Correct,
letter they
correct,
would have put a letter saying that
correct. No,
here the
that is
interest
not
of,
there.
there is no such condition.
No condition, and that is quashed, then. Then what we can do is we can say interest attendance, we will have one transfer. We'll take it in vote.
Percent interest, the date of appeal will say.
Yes. We pass orders. Reserved.
There is a pending product.
Here only,
Same bench.
it should be least considered. Least considered.
Yeah. Yes, they should.
Your lordship, but pass any orders or request not the lordships to extend further time even for the modified order or PM.
Yes.
Number 3, government advocate.
For the state, my lord. See, AG matter, it may post for next week, my lord.
Writ
You
appeal dismissed on the ground of delay.
Please, my lord.
Specifically considered that other appeals are admitted and pending.
Pending, my lord. Yes, my lord.
The-
Pending before the court was.
Specifically considered by the bench which considered the matter, paragraph 5.
Please, my lord.
Nothing in this. We'll say that the dismissal of the appeal was simply on merits and it will not affect the legal questions raised.
Please, my lord.
It will be only inter partes between you and this
Please, my lord.
specific respondent.
Yes, my lord. Yes.
It will not affect the question of law or the consideration in that also I think has been said.
That is.
It was also said. Everything. Let's just stay on the expenses. Nothing to interfere. We'll only say that this is, yes. No ground for
Else
review
may-
because
It may pass over, my lord. I'll take. Please.
no ground for review. Everything that you are arguing in the RP
Yes,
has been considered in the judgment.
yes, my lord. It may kindly pass over, my lord.
Pass over.
4 adjourned. 5,
Notice. MFA notice has to go. Notice.
Preliminary hearing, number 6, government advocate.
Ready, my lord, maybe after.
Password.
7, Vinay Kirti.
Completed on 10/11/2021. After directed the government advocate to produce the original record.
Chit. Dispute raised.
And secure the record.
Hmm.
Any date for hearing the last year.
What is the issue?
Pertaining to the last paper. So there is a, they sought for the respondent sought for the claim of the chit fund. Claiming that we are not in the full payment of the chit of the 70.
Hmm.
There is a view of 3.5 days. Our
Hmm.
contention is that we already made the payment and also the balance sheet they adjusted among the other chits. Can you wait for hearing?
Just a moment. Carefully consider private. Chit company has initiated criminal proceedings under negotiable instruments. This is a deposition of K. Keshava, managing director of petition. Deponent in the affidavits verifying the petitions. K. Keshava stated in his evidence that in all he has paid 8,66,62,704. The total amount paid shown is 8,62,41,229. Cannot be alternate views in arithmetic, can they? Question is only this.
Yes.
What is the amount they've paid? Is anything
To be paid.
further remains to be paid?
Lord, only one sheet, calculation sheet, I'll show you to Lordship.
Yes.
That
I'm
annexure
sorry
R1.
to intervene, my lords. I beg to appear for the appellant.
Yes.
I'm so sorry, my lords. I was not online when your lordships took it up. My lords, I just wanted to point out that by the order of 10/11/21, your lordships have admitted these appeals. So if my lords are inclined, the matter could be kept for final hearing next week, my lords, and we will assist your lordships.
Just a moment, can I? Yes.
Lord,
Please tell us what is the
Lord, page 118 of the appeal memorandum. Let's
118
118
R1.
R1.
Hmm.
Lordship got it.
Yes.
So there is a tabular column.
Hmm.
Let the appellant,
Hmm.
it was the member for 11 chits,
Hmm.
chit groups, millets.
Hmm.
Lord, we have furnished the total amount for which millet chits were bid.
Just to understand, cooperative society is conducting the chits.
No, millets, the chits would be conducted by the respective companies only.
Okay.
Respective companies. It is the respondent number 3 is a registered chit company.
How does it come within the jurisdiction of the JCRS?
Please, nuts, in order to recover the amounts due from the chit member, the chit fund company has to approach the deputy registrar of cooperative societies, who is the authorized officer under the Chit Funds Act.
Yes. Okay. Okay. Yes.
Annexure R1
Hmm.
is a tabular statement, millets.
Hmm.
Here, millet, he was member of 11 chits.
Hmm.
Millet, there is no dispute up to serial number 6 millets. Serial number 1 to 6, there is no dispute.
Hmm.
Serial number 7 to 11,
Hmm.
millet, the third column is the chit value.
Hmm.
And then, my lord, there is one column, my lord, check payments, lordship. Ninth column, my lord,
Yes, yes, yes.
check payments.
Hmm.
My lord, we have received from the appellant a total sum of rupees 8,65,84,000.
Hmm.
Next column, my lord, is cheat payment adjustment.
Hmm.
Adjustment in the sense, my lord, if he has bid for one cheat, if there is an amount, on his request, the cheat value would be adjusted to the remaining cheats for which he has to pay the subscription.
Hmm.
Next is the interest.
Hmm.
This is for belated payment of cheat amount. Next is dividend. He has been given dividend of rupees 2,95 lakhs.
Hmm.
Next column is the total amount. Kindly come to on the left hand side, the total cheat value,
Hmm.
20,50 lakhs.
Hmm.
The check payment received 8,65 lakhs.
Hmm.
Cheat payment adjustment 5,51 lakhs.
Hmm.
Interest 5,85 lakhs. And dividend accrued 2,95 lakhs. Total sum which we have received as against 20,50 lakhs is 17,12,79,000. The balance due was 3,37,20,000. This pay the submission. This statement.
Are there not discounts in the amounts they have to pay
After
in
the,
chit transactions?
yes, madam.
They don't have to pay the entire 20 crore 50 lakhs. Even according to
Yes,
the schemes,
Yes, madam.
they have to pay only lesser amounts.
Correct, madam.
How
That-
can you just say 20 crore 50 lakhs minus what
No,
they paid is the
no,
amount paid?
the column dividend,
Hmm.
that is the discount given to them.
Hmm.
2,95 lakhs
Hmm.
is the discount.
Hmm.
We have taken that money for calculation of 20 crores to 50 lakhs. We have given credit of 2,95 lakhs, which is the dividend accrued. Dividend in the sense, the value which they get it on account of the profit. And this statement, your lordship may kindly see.
You'll have to hear them anyway.
Your
Yes.
lordship may hear it. Only
On
one.
what date, senior counsel?
Lords, any date next week, Lords, as convenient. Could my Lords have it
Might
on?
take some time.
Let's only
It
this
will
point.
take
Only
a
one.
bit of time because I
Sorry.
would need to take my Lords through the two orders.
Not next week.
In fact, my
It
lords,
will be on the 11th, my Lords.
Can it be 12th?
Please, Lords. 12th for final hearing.
12th.
only one sentence of the statement
Yes.
of objections,
Yes.
page 115. lordship, may
Interim
kindly see.
order may kindly be continued.
Yes.
Paragraph number 15.
Huh.
In fact, I have made a statement on oath. Paragraph 15, may I read, my lord, only 3 sentences.
Hmm.
The aforementioned, with regard to this calculation, my lords,
Hmm.
the aforementioned calculation has been duly certified by the internal accountant of this respondent, and it is open for the petitioner to get it certified from any reputed chartered accountants or auditor who are in the panel of chartered accountants maintained by the company court of this honorable court. The grievance is only with regard to the calculation. Let this statement be certified by any chartered
We'll
accountant.
consider.
Please.
Yes.
It would not be that simple, my Lords. The
Let's-
original authority, in fact, I'll take your Lordships.
12th.
Interim order to be continued.
Yes, interim order.
Grateful. Grateful.
Eight adjourned, number 9, Anil Kumar.
ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ ಆ ನಂಬರ್ ರೆಕಾರ್ಡೇ ಇಲ್ಲ ನಮ್ಮ ಆಫೀಸಲ್ಲಿ
Yes.
For the state, my lord. The grade 2 Tahsildar is present from, grade 2 of care is present. The documents which are, they are seeking are not available in any office. We are issuing the endorsement to that effect, my lord. No, my lord. That particular number is not available. That survey number 54 is available. It matches some other grantee. The grade 2 Tahsildar is present to that effect. We are issuing the endorsement. What is spreading the manual record? The document is not present either in care from Bengaluru East Taluk, South Taluk, Special DC, and Deputy Commissioner. We are issuing endorsement to that effect, my lord. Please, my lord.
My lord,
Please.
may I make submission? My lord, Annexure A, my lord. It is a order passed subsequent to the order passed in Annexure B, my lord. So far as Annexure A is concerned, my lord, there should be a order to this effect, my lord. Even that record suffices this honorable court to proceed with the matter, my lord. No, sorry, my lord, Annexure.
Annexure A we have produced, my lord. The original documents are with us. They are seeking this. Annexure B they are seeking. That document is not available.
Annexure A records, let them place.
Original document
Yes, ma'am.
that are available.
Yes, ma'am.
Yeah. Yes, yes, ma'am. In the. Please. Please. Mark, mark it.
Original.
Original. Should be the. This document is not available, my lord. Grade 2 Tahsildar, my lord. Yes, sir, Mahesh. Please. Anywhere. Bangalore East Taluk, South Taluk office, Special DC, and Deputy Commissioner Bangalore. RC office alva. RC office ಅಲ್ಲಿ ಇಲ್ಲ. ಎಲ್ಲ ಕಡೆ. ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಆದಾಗ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಎಲ್ಲೂ ಇಲ್ಲ. Malad? I will do that.
Yes, ma'am.
Please issue a clear endorsement to that.
Please, ma'am.
Once the endorsement is issued, and if the rate is
Please, ma'am. Madam, on paper.
ಆಯ್ತು your turn. ಆಯ್ತು ಆಯ್ತು ನನಗೇನಿಲ್ಲ I can.
10.
Serial, may I request for password may not, or it may be taken.
Lords, I would put it this way, my lords. I fully understand what is passing in your lordship's mind. But the question is whether this learned single judge could have permitted a person who was found guilty of fraud to retain the usufructs of the fraud on the ground that there is a civil suit pending. Because civil suit was there. Even when this khata is changed, the civil suit is still in existence. It is not that the civil suit comes later. What's the... Yes. This is the difficulty, my lords. That's... Now your lordships may kindly see the order impugned before the learned single judge. No difficulty, my lords. I have, my lords, now the question is this, my lords. When a statutory authority in exercise of statutory power returns fact-finding that there is a fraud without delving into the question as to whether that fraud is there or not, whether this honorable court would permit the person who is found guilty of the fraud to retain the usufructs of the fraud. That's the question which I have raised. Notice, this is the learned single judge doesn't tell. Notice, ultimately, the only question was this. I can understand. Notice, so far as khata is concerned, it goes without saying that this is for the purpose of fixing the primary liability of payment of the assessments on a given person. Civil court will be decided on the basis of the materials which will be placed. An observation to the effect whether, because there are umpteen number of judgments, I don't think, that the learned single judge has said something new with other than the law which has already been declared. But the list before the learned single judge was something else. The list before the learned single judge is that the petitioners came before the court that the findings of fraud which is recorded against them, whether it is correct or not. That is a finding which needs to be addressed, my lords, by the learned single judge. Lords may kindly have a look at the order passed, my lords, by the competent authority, my lords, which was impugned before the learned single judge. 265 at volume 2. Yes. This is the endorsement which I am referring to, my lords. To start with the facts. Lords, may I just take your lordships first to the orders impugned before the learned single judge at page 147. Yes. Yes, my lords, BBMP. Lords, there, the relevant portion which I will be taking your lordships through is commencing from page 164, paragraph number 15. In view of the documents, written statements, written objections, written additional statements, counter statement filed with the appellants and the response in this case, detailed oral arguments addressed by the advocates during the course of inquiry, notice issued by the first respondent being the notice issued lawfully for reasons mentioned hereunder, it will be able to take the stand. It is provided a chance, there may be some aberrations in the translations, so I'll try. The khata has been made in the name of the first respondent by fraud by illegally taking earlier panchayat records, which were kept under safe custody in the BBMP office. Therefore, the action can be taken under section 114A for cancellation of khata. In order to initiate action under 114A of the KMC Act, the power vested in the Honorable Commissioner has been delegated to the Joint Commissioner under section 67 of the proceedings dated so and so. The illegality has been committed after the establishment of BBMP. The then Gram Panchayat, in the statement given by them before the police in the year 2008 itself, has stated that the khatas were not stood in the name of the first respondent in the original documents of earlier Gram Panchayat. Further, the khata is not entered in the khata registers handed over to the BBMP from the Gram Panchayat. From this, it is confirmed that the documents which mentions the name of the first respondent are not based on the original documents. It cannot be said that the khata issued to the first respondent comes with the principle of estoppel because this khata is not made out by obtaining permission from the competent authority. This is a commission of fraud and khata is effected illegally. For all these reasons stated above, the objections raised by first respondent are set aside and the proceedings in the inquiry is continued. Further, in this regard, the first respondent having filed a suit in OS number 209 of 2004 before the Honorable Principal Judge against the third appellant seeking order of permanent injunction in respect of properties bearing khata, she has produced Xerox copies of the decree of the order passed in the said court on 14/3/2012. Further, in respect of property of same khata, the first respondent and others have filed a suit in OS number 1518 of 2004 before the Honorable Civil Judge against the third appellant and seeking other declaration permanent injunction in respect of the property that have been produced a Xerox copy of the plain stating that the said case is pending. However, BBMP is not paid in this party in the said case. Further, they have not mentioned either about the illegal entry in the khata, either in the BBMP register of obtaining approval from the competent authority in accordance with law, or either prior to handing over the panchayat documents from the earlier Ramgondali Gram Panchayat after establishment of BBMP, or in order to establish that either the name of the first respondent in the register at the time of the khata or the names of any other respondent was mentioned. They have not stated before this authority or in the civil suits. Further, the copy of the judgment and decree is found in the matter of pendency of inquiry before the authority since 2008 in respect of the illegal khata is not brought to the notice of the civil court. Then this is important. BBMP, which was established in accordance with the government notification of 2007, has taken former 7 TMCs, 1 TMC and 10 villages to its jurisdiction. Thereafter, according to the notification issued by the commissioner in 2007, Mahadevpura range having come into existence, all the villages coming within the jurisdiction of the Ramgondali Panchayat are included within its purview. Siddhapura village also being coming within the limits of Ramgondali Gram Panchayat being a village, it is also included in Mahadevpura zone. The joint commissioner, the then joint commissioner, deputy commissioner who visited the Gram Panchayat officers have taken in charge of the records, assets and liabilities being maintained in the Gram Panchayat, which are so included, have verified the assessment register of Siddhapura village on 3/2/2010. Taking into custody, notice the entries therein. Kindly mark this. Serial number 1 to 541. These are the only number of properties which are there in that khata. Both of them have been affixed their signatures. It's underneath the entrusted the register to the Assistant Revenue Officer, Whitefield, for safety. For the reasons that the required officers did not avail for the newly established BBMP office, officers who were earlier discharging their duties in the CMC and panchayats were appointed then, and thereby giving new designation according to BBMP stamping pattern, according to the staffing pattern, my lord, that is, according to their respective class and grades. Similarly, 8th respondent, who was formerly Secretary of Ramgondali as Revenue Inspector of the Vartur, and 9th respondent as Tax Inspector were also reappointed. The respondent 1 to 7 in this case, in collusion with the respondent 8 and 9, who are the BBMP officers, for the purpose of making illegal khata in respect of revenue sites, layouts which was not converted and also not approved by the competent authority, have taken Siddhapura village assessment register of earlier Gram Panchayat, which was under the custody of the in-charge Assistant Revenue Officer by name Shri Keroji Rao, into their custody by assigning the reason that it is required to make entry in the BBMP register below the entries, therein which were duly declared and signed by the Joint Commissioner and Deputy Commissioner, have illegally made khata entries from 542 to 554 in the name of respondents without getting approval from the competent authorities. There are no either basic documents or any sort approval from the competent officer which is required to be obtained according to the BBMP rules, or any earlier proceedings with regard to the earlier Gram Panchayat has granted its decision are available to such entry of khata. Further, any of the respondents have not produced documents with regard to the proceedings. Therefore, these illegal documents, being the documents created for the personal interest of the respondents, are tainted with action of fraud, unlawful. Further, from any of the objections and documents submitted, the respondents are facts found, so on, so on. Let's the once, because these are certain things which is going to the root of the matter. Very serious issue. It's a manipulation of the official records of the government if it is found faulted with the competent authority while exercising powers in 114A with being a quasi-judicial authority. Because that could not have been upset. They are retaining the benefits of the fraud. Then again, my lords, in the last, they say that they have initiated even proceedings, my lords, as against these officers. Lords, now if your lords were to see the grounds raised in the writ petition is essentially challenging these findings, the learned single judge doesn't get into these findings.
My order, my lord, which is
Basic principle is that party.
my lord.
It's one judgment, my lord, of course.
My lord, I have nothing more to say. As far as page
Lord.
number 146, my lord.
My lord, please see, my lord, page 19, para 4. Here, my lord, says learned counsel for the petitioner submits that the property of the petitioner was assessed to tax by the erstwhile village panchayat, and after the area fell within the limits of Municipal Corporation. Corresponding entries were made in the assessment register extract. He submitted that the respondent number 5, having suffered an adverse order in the suit for perpetual injunction filed by the petitioner, has now filed a suit for declaration of his title in OS number 879 of 2015, which is pending consideration before the Senior Civil Judge, Bangalore Rural District. Likewise, the petitioner claims to have also filed OS number 1518 of 2004, which is also pending consideration before the Senior Civil Judge, Bangalore Rural District. He therefore submitted that the impugned order passed by is without jurisdiction. Now please see, my lord, page 21. There, my lord, as such, the entries were fraudulent and the kata of the properties made out in the name of the petitioner based on such fraudulent entries is not sustainable. Learned Senior Counsel did not dispute the fact that the petitioner and the respondent 5 had filed suits against each other for declaration of their title. So therefore, what the Learned Single Judge comes to a conclusion, my lord, since suits are for declaration and that, my lord, the petitioner has already suffered an order for injunction, and thereafter, my lord, he has sought for a larger relief, that is a declaratory relief. But the Learned Single Judge of this honorable court, my lord, felt that it is just and proper that the civil suits are to be adjudicated, where, my lord, title itself is in dispute. So question of changing the entries, my lord, would not arise. That is the reason, my lord, at para 6, as my lords already observed, in view of the civil suits filed by the parties against each other, it is appropriate to direct that the impugned order shall be subject to the outcome of the civil suits referred above. Consequently, revenue entries in the name of the petitioner in respect of the sites mentioned above in the records of the BBMP shall continue to exist till disposal of the civil suits. So they...
Is not vacated. Cannot be taken.
It's just one more fact, minutes. What happened? This was an order of 2014. 2015 writ petition was filed. Interim order was not granted, minutes, by the Learned Single Judge. So khata was struck off. So from 2014 to 2022, the khata was not standing in their names. It is for the first time, again by the orders of the Learned Single Judge, it comes to be resurrected. Of course, it's not yet done because of your lordship's intervention by passing an interim order. Hazi Hamza's case, minutes, of course, I had. No. It is only been struck off. That's it.
My lord,
one judgment, my lords, of the Supreme Court. Copy to it. Notes Hazi Hamza's case, I'd asked them to get it. Notes. It says that usufructs of the.
my lord, now that, my lord, my Learned Senior Counsel is addressing.
Para 34, my lords. Notes, I will also submit that Hazi Hamza's case. Para 34, sorry.
My lord, my request for passover or, my lord, matter to be taken up the next week, my lord.
Para 34, my lords, in this. But of course.
Since, my lord, this contention of fraud not having been, my lord, looked into.
Yet another decision in Hamza Hazi. It has been held that no court will allow itself to be used as an instrument of fraud. No court by way of rule of evidence procedure can allow its eyes to be closed to the fact it is being used as an instrument of fraud. The basic principle is that a party who secures the judgment by recourse to fraud should not be enabled to enjoy the fruits thereof. Now, there are several other judgments on the same point. Hazi Hamza elaborates this point.
Passover or, my lord, next week, any date may be fixed for that. Before 5th of February, any date.
Very well, Lords.
Just come up with also some citations, my lord, may request for two days accommodation. Before 5th of February, any date may kindly be fixed.
Anyways, I'm in your lordship's sense. Lords, first there is some. My apologies, sincere apologies, my lords.
Third or fifth, please.
Please, my lords.
Obliged.
11, Abhishek Malipati.
May I please? This is with respect to postgraduate medical counseling, my lords. KE had notified initially a procedure, my lords, regarding the conduct of 4 rounds of counseling. If your lordships were to kindly see at page 22, They have specifically notified that all the rounds of online seat allotment, well, it's page 22, last paragraph. All the rounds of seat allotment would be conducted as per the directions of the central government, National Medical Commission, Medical Counseling Committee, state government, apex bodies. The schedule of each round will be hosted on the KEA website. Very next paragraph regarding mop-up round of counseling, my lords. Very next page. Eligibility to participate in each round is subject to the conditions stipulated from time to time by MCC. KEA will not be held responsible in this regard. This mop-up round is the third round of counseling. What stood earlier, the procedure is after upgradation of an allotted seat would be permitted only up till the second round. From this academic year, there is a change in procedure, where MCC has allowed upgradation up till the third round of counseling. That your lordships will see, at page 29, which is the notification, at page MCC has notified the procedure after KEA's notification at Annexure C, relevant page at 29, Point 1.4. Serial number 1.4, which is highlighted. In supersession to previous scheme, it has been decided by the competent authority that upgradation will be permitted up to third round, which was earlier known as mop-up round. Accordingly, NMC will approach the Honorable Supreme Court of India for approval in this regard. Candidate is allowed to upgrade from a seat from second round to third round. Candidate advised to take procedure. Petitioner has been allotted a seat in the second round of counseling. Third round of counseling is now notified. Even before I confirm my seat in the second round of counseling, I have informed KEA that in light of your notifications, I'm confirming the seat by making the payment of fees. But please permit me to appear in the third round to upgrade my seat. Yes, my lords. But they have now permitted me. Because the authority which notifies this procedure is the central government. No. Yes. Yes, my lords.
Yes.
Yes, my lords. Yes, my lords. Now, paragraph 1.5 makes it clear, my lords. Central authority has notified because it's, my lords, the Honorable Supreme Court has only notified what central government had placed before it as to what the procedure will be. It was not a procedure, my lords, contemplated by the Honorable Supreme Court. It was only central government saying there are going to be 4 rounds of counseling. Upgradation will be permitted only up till the second round, which was, my lords, notified by the Honorable Supreme Court. Now they have changed the procedure, allowed, my lords, me also, all students in the country to upgrade to third round. I have now been permitted by All India Counseling, my lords, to upgrade into the third round. That procedure is already implemented. My lords, this is also, your lordship would see in paragraph 1.7 also, my lords. 1. Yes, my lords. Yes, my lords. In this very case, my lords. Yes, my lords. Onwards, yes, my lords. This is again what was, yes. Yes, my lords. Yes, my lords. Yes, my lords. Yes, my lords.
Without which the scheme does not have.
Yes.
Change in the scheme does not have.
Yes. Lords, if you lordships kindly see 1.7 also, that extracted paragraph also makes it very clear. The development of the above software, lords, this is, lords, the common counseling regarding the entire country. The development of the above software should ensure that a uniform pattern is followed by all states across India, commencing from the academic year 22-23 onwards. From the current academic year, since the students have already joined, so and so have commenced, we would be in the interest of justice to put an end to the contempt proceedings. However, we take on record the assurance which has been set out by the DGHS and directed that all states and counseling authorities in NEET UG shall scrupulously follow with the above directions from the academic year 22-23 onwards. If your lordships were to kindly see, my lords, KEA, my lords, this is the procedure already notified by the central government. What your lordships are reading, my lords, is the procedure already notified by the central government. It has already permitted me, my lords, the third round of counseling upgradation. Third round is over, my lords, by All India Counseling. I was permitted to participate. I have not been allotted a seat, my lords. Yesterday, my lords, they have announced the results of the third round of counseling. In the entire country, third round, students were permitted to upgrade. This procedure has to be followed, my lords, in terms of... Yes, my lords. Yes. Manoj. Yes, Manoj.
Yes.
Manoj, when I am permitted to, Manoj, I've been allotted a seat. Manoj, regarding the upgradation, if All India quota, Manoj, they have permitted me to upgrade. State quota also should permit me. Otherwise, Manoj, second and third round, students, additional seats are added, Manoj, in the state quota. I will not be precluded.
Yes. Upgradation will be episode. Because that is enhancing the court of which the property they have.
In which case, Manoj, no, Manoj, I would only like to, Manoj, address this by this, Manoj. In page 23, your lordship may kindly see. Regarding the third round of counseling, what KE has notified. Please, Manoj. Mop-up round. This is the third round. Eligibility to participate in each round is subject to conditions stipulated from time to time by MCC. This is the condition, Manoj. They have said, whatever MCC says, we are going to follow. Yes. Schedule. The same, no, Manoj, the same procedure. This is the same procedure, Manoj.
Yes.
I would, Manoj, interpret this as, Manoj.
Yeah, Manoj, as far as petitioner is concerned, it's a bichos petition for the simple reason. Manoj, my friend has produced only up to Manoj, the page 8 of the MCC guideline. In MCC, Manoj, their procedure is altogether different. They have every round, Manoj, they have registration. Every round they have registration. Here we have only one registration. And Manoj, options only once. And my lord, in KEA, my lord, this procedure is followed in uniformly. We are doing, my lord, the integrated counseling. My lord, this is no more the very issue, my lord, was decided, my lord, in Vishnu Verma's case, as far as UG is concerned. Similar, my lord, once second round is over, second round, my lord, student has to necessarily go and join the college. In this case, she has gone and joined the college. Your lordship, kindly see why they are asking for this. The reason for, my lord, at page, my lord, page 8 of the petition. They very well know, my lord, that there is no, my lord, the further round for them. Last sentence of the petition, the first para, that the petitioner, being the only daughter of the parents, wants to be able to secure a seat closer to the hometown and to secure a seat which is less expensive as that of the allotted. See, it has been allotted to her. Yes, it has been allotted to her, and it has been specified in the brochure itself. They did not challenge the brochure earlier. And at this juncture, they come and say, my lord, the whole thing has to be redone. That, my lord, it can't be countered. This is what, my lord, this honorable court has held. The division bench in Vishnu Verma's case. May I read, my lord? The first para itself, my lord, the petitioners have preferred this petition, seeking relief inter alia to declare the condition imposed in the notification dated 22/8/2017 as illegal and arbitrary, and it is also prayed that the said condition is contrary to direction issued by the Apex Court in its order dated 9/5/2017. The petitioners have further prayed to direct the respondents to permit the petitioners to participate in the mop-up round of counseling for the surrendered medical seat being conducted by the Karnataka Examination Authority for short. Then, my lord, this honorable court, while holding, my lord, para 5 onwards. We may record that in the brochure of the admission, which started on 5/7/2017 at page 23, following was the instructions already made known to the students concerned. Process of allotment of seats and admission to postgraduate post-seat allotment procedure, choices before a candidate. The seat matrix issued by the government for each discipline will be adopted for allotment of seat. College-wise, course-wise, and category-wise seat matrix issued by the government will be hosted on the KEA website for the information of the candidates and parents. The allotment of seat will be conducted in 2 rounds, and each round consists of 3 phases, and each phase consists of number of iterations. First round, second round, my lord, there is a clause. Note, if any seat remains vacant after the second round, a mop-up round may be conducted for all categories of seats in which only candidates who have not been allotted any seat in the previous 2 rounds would be eligible to participate. That is PG also. They have to necessarily go and admit to the college which they have not taken. She has paid the fee, gone to the college, admitted to the college. Now, as an afterthought, since it's a closer, she wants to come. And what happens to that? That she has already been allowed. Somebody would have taken the second round. They will be deprived if that has to be surrendered. Therefore, this can't be counted unless the prayer made is to contrary to the specifications. For the prayer is to consider the representation. Therefore, it can't be.
Medical counseling comes. May I please, Manoj? Manoj, the argument that I should have challenged, Manoj, the procedure is unfounded because of the fact, Manoj, that they have very specifically stated in their brochure that the procedure that they are going to follow, and regarding the eligibility to participate, Manoj, it is not the procedure or the schedule, Manoj, that is being argued now. Eligibility to participate in each round is subject to conditions stipulated from time to time by MCC. This is the Malod's statement that they have made in their brochure, Malod's which we understand that they will follow whatever MCC has told them to follow. Accordingly, Malod's, there is no procedure for us to challenge it. Malod's, Supreme Court has also said, Malod's, the other matter in contempt, the procedure and the manner of conduct of the counseling has to be similar in the entire country. There can't be different procedures. Malod's, that is what it said, Malod's, in paragraph 1.7 in the brochure which has been shown here. Malod's, page 30, paragraph 1.7, vide order dated so-and-so in contempt petition number so-and-so, Honorable Supreme Court of India, it has been approved that MCC of DGHS has developed a software for all participating states and counseling authorities. Furthermore, it has been directed by the Honorable Supreme Court that the development of the above software should ensure that a uniform pattern is followed by all the states across the country commencing from the academic year 23-20 onwards. The procedure, Malod's, has to be the same. Malod's, date of the brochure by KEA is 7/7, Malod's, 2024. MCC has notified in August, Malod's, afterwards.
In fact, my learned friend has just
Malod's, other states also, Malod's.
Yes, we received the information just now, Malod, after this.
No, Malod's, they need not specify, Malod's, but KEA itself has said that they are going to follow. Yes, Malod's. Second respondent. Yes, ma'am.
in respect of all India quota seats. Permitted participants in the counseling process. Improve their options. In the third round of counseling. This is called the Mocha Proud Answer. The decision was taken by the third respondent in August 2024 after the issuance of NHC brochure. It is further contended that NHC itself provides that the upper round of counseling will be conducted that the eligibility to participate in each rounds, including the mock-up round, will be subject to conditions stipulated from time to time by the agencies. It is contended that since the NCC has permitted the candidates who have appeared in first and second round of counseling and who have secured seats in either of those rounds also to participate in the third round of counseling and to better their options if such options are available. The same option should be made available to the candidates aspiring for state quota seats as well.
No, my lords, it's slightly different, my lords. For all India quota, my lords, they take note of, my lords, whether the student has been allotted a seat in the state quota also, because they inform, it's a common software. Once they are allotted, my lords, in the state, earlier they were not permitted to participate in the mop-up round or the third round, even for upgradation from state allotted quota to all India quota.
What the criteria for the all India quota allotments, and that earlier even persons who had been allotted seats in either of the first two rounds of state council would not be eligible to participate in the third round of the all India quota. It is submitted that since now the all India quota permits the third respondent permits students, candidates in the all India quota who have participated in the first two rounds of counseling and they have obtained seats in such rounds also to participate in the law. So they will be applicable to state quota seats as well. So counselor sharing for the AEA submits that the brochure of the AEA was one issue on 2722. It was clearly stated in the brochure that persons who participate in the first two rounds of counseling and secure seats in either of the first two rounds would be ineligible to participate in the counseling. It is submitted that the said provision brochure stands unamended and that there is no challenge raised by the provision in the bill. It is further contended that the fact that third participation in the third round has been made possible participating in the third round of counseling under the all India quota has been made available even to candidates who have secured seats in the first two rounds of counseling. They may be the situation since in the all India quota, registrations are provided independently for registrations and options are provided independently for all three rounds of counseling.
My lords, fresh registration is permitted for this round of counseling by KEA. That notification also I have placed. Then, my lords, oral statement. My lords, I have placed even, no, my lords. No. Kindly, my lords, may kindly see. So earlier, no, students who are eligible earlier have also been permitted to participate now.
allotment of seats and voting allotment procedure for the using allotment procedure. I think the thing is considered by in forward. Without going to the cannot be a change in that procedure. It has been seen by the state. Then, BBMP appearing for the further comment. Also submits that the change in the procedure, that the change in the criteria with regard to admission to all India quota and the permission to participate in the third round. Granted even the persons who have participated and procured allotment of seats in the first two rounds is limited to the all India quota, and that the state governments and the competent authorities conducting the council are free to provide separate criteria with regard to participation in the third round of council. The subject that means the brochure issued by the KEA specifically states that the permission for the third round of council is to be limited to those persons who have not secured seats in the first round. The change in criteria for the all India quota cannot be automatically applicable. The mock-up round being conducted for allotment of dates of authorities, including the schools. What is your contention with regard to the registration being done?
Malod's at page Malod's 56, Malod's annexure H. Next paragraph also. Next paragraph also. Malod's in that Malod's third paragraph, PG candidates who were eligible earlier but not registered can also register. Kindly, yes, Malod's the very next underlined portion below, just below that. Yes, all.
Mock-up round of council after the first and second rounds of council would be limited to candidates who have not joined colleges after allotment of seats in the two rounds of council. The broker is not understanding. We notice that the raising commission with regard to had been subjected to a challenge before the court and had been upheld by the judgment of the court, which is the judgment of the court dated page 9, 2016. Further, we also noticed that the change in the procedure and the permission granted candidates who have take your seats in the first two rounds of council to participate in the third round of council, which is relied on by the learned counsel for the petitioner, is limited to the All India quota scheme, and it is the specific case of the third respondent that the said provision would not be applicable to the counseling procedure prescribed under NHB brochure. In the above view of the matter and in view of the specific provisions contained in NHB brochure, they are unable to accept the contention raised by the learned counsel that the provisions, that the statement that eligibility to participate in each round is subject to conditions stipulated by the MCC would mean that the change in criteria under the All India quota scheme is to be automatically made applicable to students participating for admission to state quota seats as well.
Hearing on IA, number 12, SV Butt.
Those ideas do not have to serve on the parties' mind. They would actually be attended by a week or two.
Ramchandra Reddy. DS Ramchandra Reddy. DS Reddy. Thirteen to. 13 to.
I filed, I filed an IA, my lord. During pendency of the appeal, the advocate, Satish Chandra passed away, and for a short period, R. Nataraj advocate was taking care of. Now, while going through and getting ready for arguments, I found this IA is very much essential to see that what is mentioned in the body of the plaint has been left over in the prayer. That would frustrate the purpose of the suit as well as this appeal. So I found it very much essential to seek this amendment in the interest of justice, and my right will be denied. Yes, it's already filed, my lord. 3 days back, I already filed.
He says there is some application for amendment which is pending. Here it along to the.
Well, the trial court suit came to be disposed of, which came to be filed in 97/2012. Immediately, I moved the present appeal due to irregularities in the judgment passed by the lower court. And my humble submission is that, my lord, if the amendment were to be not considered, immediately on 12th, 2012, I moved the present appeal. And due to natural reasons of development of settlement by and between the parties, the matter was being kept pending. I've been regular to the court. I'm not avoiding, my lord. Yes, my lord. I'm sorry, my lord. Saturday I served and then filed, my lord. No, my lord, unless the IA has been considered, IA has to be put up, my lord.
Yes, when will you be ready to argue the matter?
No, my lord, because of the development I mentioned just now, the IA has to be considered. I am not prepared for a short date may be given, then the IA may be put up and I will be ready with the arguments. Reserving without not closing the doors for reconciliation by and between the same parties. 24/2, ma'am. Yes, ma'am. Yes, ma'am. I will clear, ma'am. I will take care of it.
Yeah, Krishnamurthy.
Yes, ma'am.
This is the matter. Yes.
The man.
Yes, the lead case in the batch. Is that the batch?
No, this is not the batch. Yeah. Lord, an order has been passed under the Karnataka Protection of Interest of Depositors Act, Section 3, attaching the certain properties. And subsequently, after the appointment of the competent authority, filed an application before the trial judge. He made the attachment absolute by the impugned order. This order has been in challenge, my lord. The petitioner is one of the depositor with the financial establishment. That is respond number 1. The for the adjustment of that, I was following up with this one for repayment of the money, and there was a settlement between the depositor and the financial establishment, under which the financial establishment, which has booked a certain apartment, has agreed to give up one apartment in my favor, which is the value of about 35 lakhs. And of course, 39 lakhs is the value, 4.5 lakhs I have paid. And when sale deed was also executed. After that, this attachment has come and notice has been served, I have appeared. The ground on which my application has been rejected and attachment made absolute is, it is a Benami transaction. Now, the judge, while giving the reason, your lordship may kindly see the relevant part, 14L in page 50 of the order. Of course, judge has proceeded on the right basis that Benami transaction, since it is alleged by the competent authority, it has to prove. And the judge has then considered whether I have produced any document to show that there is a settlement pursuant to the settlement, because I am one of the depositor. The judge has arrived at the conclusion that I have not produced any document at all, though I have produced the document to show there is a settlement. Now, kindly see para 14L, my lord, page 50. Along with the above aspects, it is also to be noted that no documents is produced to show that there was settlement between the respond number 1 company and the respond number 2 and his son as contended by the respond number 2. There is nothing in the sale deed to that effect. If at all the contention of the respond number is true and genuine, the sale should have been reflected in his sale deed. The same should have been reflected in sale deed. There is no any explanation by the respond number 2 in this regard. For this matter, lordship may kindly say, I have produced the annexures which are produced before the trial court along with this file. Kindly see the sale deed. Yes, sir.
5 lakhs is the same deposit.
4.5 lakhs I have deposited. No, 35 lakhs with the financier I have deposited. But apartment value is 39 lakhs. That excess amount also I have paid. 5 lakhs with the financier, which he is supposed to return to me.
For that, he agreed. He has booked one apartment with a developer. And he said that, no, I don't have money. I can give up that this one. I have already deposited there 35 lakhs for the, I have paid advance for the apartment. You take that apartment. Excess amount to be paid to the developer, you pay. That's how I paid 13/11/2018. Your Lordship, may kindly annex D, page 95. Yes.
The notification is.
No, the notification, I have produced the notification also. Notification on 31/1/2019. Annexure E, page 112.
Yes.
Now kindly see even before regarding settlement. Yes. Because it cannot be a benami. If my own amount is, I have purchased an apartment, then it is not a benami transaction at all. The judge says, in my name, the financial establishment has purchased that, it has paid the consideration. Since it has paid the consideration, it is a benami transaction, and therefore this property is liable for attachment, which is, according to me, factually wrong, having regard to the document produced before the trial judge. Kindly see page 94, my lord, our settlement, where no objection was issued by this financial establishment to the developer, stating that there is a due from me, 30th June 2018. What is liable for attachment is the property in the hands of the financial establishment or its directors. If it is not sufficient, then it is directors, agents, or anybody claiming through them, claiming under the financial establishment, connected to the financial establishment. I am not connected. On the other hand, I am a depositor. I am supposed to get back the amount from the financial establishment through this process also. But in this case, there was prior settlement. And settlement document is also, the judge says I have not produced, but it is now factually incorrect, because Annexure C, page 94, your Lordship may kindly see, it is marked as Annexure R3 before the learned trial judge. This is from the financial establishment to the developer, Sanjaya Land Estate Private Limited. With reference to the above, we have received rupees 35 lakhs towards investment from Ilyas Khan and family, that is the petitioner. With reference to the above subject cited above, we would like to inform you that Ms. Ilyas Khan and family is having balance of business advance amount of rupees 35 with us, while all DD numbers and other things are shown. And then Ambident Marketing Limited account number so and so Ilyas Khan for flat 4,25,000. Total is 37 lakhs. And you are requested to adjust the 35 lakhs towards the sale of the flat number 308 to Mr. Ilyas Khan from our payment. Pursuant to this, ultimately sale deed came to be. Of course, there was an agreement also. The sale deed came to be. In the sale deed also it is mentioned. The learned judge has recorded that it is not mentioned. Kindly see page 99, my lord. Whereas the Ambident Constructions Private Limited has entered into an agreement of sale on 17/2/2018 with the purchaser intending to purchase the flat bearing 308 in Jupiter Block Tower C along with the proportionate undivided share in the land in Schedule A property. Whereas the Ambident Construction has now nominated the purchasers to purchase the Schedule B property along with other purchasers of the balance undivided right, title, and interest in the ownership of Schedule A property in the residential complex known as Skyview, and to acquire absolute right, title, and interest ownership of the flat bearing 308 in Jupiter Block Tower C. The property is more fully described Schedule C property. Whereas now learned judge says there is no such thing shown to the court, and therefore I consider it as a benami transaction, because the amount is under this one is shown to have been paid by the Ambident Construction. Yes, my lord. That is because, my lord. Yes, my lord. That is because my amount is with ambient marketing. That amount they have transferred it to the developer under the settlement. Settlement, they while issuing the NOC, they have stated that yes, I need to pay them 35 lakhs. Balance you recover from them. Then balance amount I have paid. That's how the transaction took place. So therefore, it may require a consideration with the all the. But the delay is due to the fact that I'm suffering from back pain and this one, and I am residing in Kolar. I could not travel. And age is also a loss of mechanism. I filed the affidavit. The delay petition is at page 151, my lord. Of course, I have calculated 266 days, but office has calculated 283 days, my lord. I have produced medical certificate also, para 7, my lord. Sorry, para 4 and 5, my lord. I submit that my advocate has applied for the copy of the order on 29/2023, and the same was made available to me, him on 26/9/23. However, I could not go over to his office to discuss the matter. I state that I was suffering from lower back pain and knee pain. I consulted the doctor on 25/9/23. Upon examination, I was diagnosed with the rheumatoid arthritis and lumbar spondylitis, for which I took the treatment from 25/9/23 to 17/7/24. Further, the doctor has advised me to take complete bed rest for the said period, because of which I could not. I have produced the certificate also. No, first time is. One copy.
Whether or not they could have been a private settlement, whether they could have been undertaking given by the financial establishment, but the exclusion of all the depositors, I favor only you. This appears to be the contention, not even a piece of evidence to carry a deposit. The entire fulcrum, the entire basis is that they are depositors. But if you know that depositors, there should be some deposit, there should be some transfer of money. Can you see what? Here is a person who pays about 17 to 20 lakhs in cash. Not even a piece of document. This is what the special court says, that if at all it is the contention that they are depositors, if this is the beginning of the story, for which there is no proof, then the explanation cannot be liable to. Whether or not this is a benign transaction in terms of the act may not be relevant. All that the court has said is, admittedly, majority of the portion of the money is being paid to the financial establishment. And when there are 1,000 depositors, one such depositors could not have been favored to the financial establishment with some substance of the finding of the honorable court. So, unless you are another senior friends able to produce some document at least here to show that he was a depositor, the bona fide otherwise would be a different question.
I have produced. That's what I read all these days. I think I have now served the cop. Yes, ma'am.
Which is now under the notification.
Yes, ma'am.
Saying that you are a depositor or not.
Yes.
Do something independently. There must be.
True, madam.
Document with regard to the deposit.
Yes, my lord. No, even for that, my lord. Now the question, now before your lordship, I have given the evidence. It is not that I have come here on the basis of records. I have come here because on the basis of evidence. Evidence is not before your lordship. So therefore, records may be called for, and let him also point out. I will also point out. Because this is after trial. The trial is under Order 37 rule. This one. There is an obligation on the competent authority also to lead evidence and rebut it once I am permitted to defend my case. No, it is there. That's why, in fact, a prima facie document I have produced before your lordship. That is, which is marked before the trial court. That is R2. That I have read it now. The financial establishment has admitted that I have paid the amount. No, let me. I have not appeared before the trial court, my lord. Even I don't. Yes. True, my lord. True, my lord. Yes. No, there is.
Examination. He says that I have no difficulty producing documents and ideas to show that I have really paid the money. But if at all, my lords, a person who is in the custody, who alone can be in the custody of the IPR, chooses not to produce it. But 114G, what the adverse inference has to be drawn.
Exactly for that reason, this is a matter for consideration, because even now I can produce those documents if at all not produced there. I don't know, because I have not appeared before the trial court. If at all it is not produced there, whatever I have deposited, the financial establishment documents, that I can even under 43 permits me to produce those documents, because I have already stated that I have got that document. Now for that, party may not be denied hearing opportunity. This is a right of appeal, my lord. Right of appeal.
But also, I think that we need to go into the proceeding subject to a condition and not create third party rights or not into the property to auction before I seek the last permission.
I
So
think
this is what
no, my learned friend is not aware. There is no apartment now today to auction also. There is no apartment. Only money is the dispute now. This money, because though no construction was construction not completed. I'm duped by the developer also. So that's why I wanted to show all those things. It is not that.
1 and 2, even 1 and 2.
Insofar as the respondent number 2, I pray for this dispensation of notice, my lord, because financial establishment may not be necessary. I am filing a memo if the lordship permits. Good. Yes, ma'am.
17 to? Government advocates?
Yes.
This was the BBMP. For the election work without the conflict about the
It live in blood. It's 111. On both the IE as well as on me.
I file a memo.
Yes.
16, Chandrakanta Gole.
I have filed the affidavit. Affidavit, I have filed it on Saturday.
Good.
And that father is also there.
No, today the matter was posted for the only reason that whether the transfer could be effected and NMC would give permission. That is the only issue.
That was the only.
क्या this is? It on the respondent one must suggest.
They were transferred to these colleges on the basis of the fee that was agreed to at the time when they were admitted. So, our stand also. Ambedkar, they took about 3 candidates. BGS Medical College, they have given a letter of undertaking for this court, where they have taken them on the basis of the earlier fee as mentioned in the admission order which was issued initially. So if there are other colleges also which are like this, out of this plethora of numerous colleges, then this issue will not remain also. So if it is left to the colleges, like my lord said, let's have it tomorrow, have it after 4-5 days. If other colleges are ready to take like this, then BGS and BR Ambedkar have said, and this is on record, based on which orders also were passed earlier, May and in October or some such time, where this has been already done. So if there are others like this, then this list will not be a list at all.
On the last occasion, my lord, there are only 2 colleges.
So if there are colleges, this was done by the students.
Yeah, because nobody will then say that we'll take it and listen.
Yeah, because of
Reciprocity not there. Willing to take it, yes. He won't stand with it. If anybody got about if any college wants to take actions that they pay, nobody stands with it. But
no, that's all.
probably may work to the detriment of the students. We don't want that.
Yes.
We don't want to be cause of that, but we are asked to.
No,
decide it on the basis
that's a
of
separate
evidence.
issue. That's a separate issue, but this is here.
My lord, sir, may I submit? May I submit? my
So
lord?
let them, let these same student, let similar students who are in the same position, apart from those who have got themselves transferred on the basis of these letters which are placed on record before the court, which says that on the basis of that admission order, like that, if others are ready to take, because what will happen is, because of this,
These are somewhat.
I think that
We don't want to stand to the way like that happen. Now,
if
we are
the,
here. Okay, listen about couple of minutes.
if the court can even say that if any college is ready to take it at that fee, it may help.
Then that means.
That again, because the court may be inclined to take a different view. That can happen. That can happen. That can happen.
As a matter of.
That can.
My lords, may I submit, my lords, here? Yes. No, pertaining to that
this-
only, my lords, it is pertaining to that only. Now, some of the colleges have not even objected to the same admitted fee, like Father Mullers and all. They have been issued with the notice, but they have not come before this honorable court. What they are expecting is, if the honorable court says you take for the same fee, then we are ready to take. Like Al-Amin and Father Muller. My lords, that is a problem now we are also facing, because those students have been admitted, they have been given attendance, they have been given permission for examination. They don't have any objection to this.
We don't want to be the reason for this. We are taking and. The things that they are paid.
Then
Because, no, my lord, because of
if
the
court would
order
say-
of the DME,
They have admitted mistake. And they have the financial commitment for that. That is necessary.
My lord, may I,
Then the question would be, if there is an additional student, what would be the financial commitment required for that additional student? May not be the full fee.
my lord,
Therefore, it's something in the work.
yes,
so
yes.
if my lord
My
can
lord-
say like this, I do not know, it's a loud thinking. Without prejudice to the contentions urged, if any college in the meanwhile is ready to consider taking them on that, because my lord will be making it clear without prejudice to the contentions urged, that may assist them in getting a foothold somewhere.
Because of this reason, my lords, because of
Some
the
prodding
assumed
can be there from the
communication by
court.
the DME, they are not coming forward to say anything. That is coming in the way of their,
This says they may not.
No, that's all right. Then,
Because
then it is up to it's
May
their
not-
fate.
There is an order of this honorable court that if they do not come, the colleges do not come before this honorable court and file their objections to this, adverse inference will be drawn. No, my lords, there are many colleges who have not come before this honorable.
Meanwhile, if there is an order like that.
Yes, yes, my lords. It is on
If my
second.
lord may say that to that extent, that without prejudice to the contentions that have been urged, if any college in the meanwhile is
It's been replaced in the corporation.
because if that is done, we will, if that is done, we will, if that is done,
Yes.
my lord, if that, my point was, if that is done, we will be filing a formal, we will approve the wholesaler in a formally also, as far as the NMC is concerned, if all of them are, even in writing. Not just saying that earlier orders have been passed by the court. My instructions are that if that happens as a matter of fact, in conformity with all of them, 13 have been done, another 17 remain approximately. If that is done, we will say, we will ourselves put it on record stating that we are going to ratify all these for all of them.
But no student has come to me asking for that.
So it needs a bit of a prodding from every quarter to see that my lord has seen the rationale partly. My lord may have a views on that. That's a different issue. But considering what I'm saying, that if a little prodding is done, it will help in getting people in place. This is all the mischief. I shouldn't. No, without 200% in their favor.
Whatever, any lesser fee that is notified, whatever is the fee that you have to pay. Then we should permit that exercise.
We are thankful that this case, my lord, students' interest is safeguarded, at least. in this
Yes,
case.
yes.
Here, don't want to say anything, either way is what we.
Even if it doesn't usually, my lords. But one thing, my lord, only one thing.
There is some.
My lord, at this moment of say that silence was for everybody I can.
We don't want to be a.
Please.
What it should be.
That's what my lord. That was also asked.
My lords, I have, your lordships asked me to file a written submission, synopsis. Yes.
It's just, in the meanwhile, if you work out something, we can record. If it does not happen, then we take it.
There are also may to put it how, my lord, but with that notified by the college and notified that by. And between that, some ocean of difference, once that communication, what prevailed, I don't want to say anything.
My lords, my submission is this, my lords.
Please.
Is there an expression of regret at least?
Yes. Much.
My lords, in fact, because of the DME order, many colleges are not coming forward, my lords.
My lord, may put it with fun, kind fun. Till my lord, settles this in some judicial order, my prayer is till then. Now that's confusion because institutions expect it should be 30 or so, and the students feel that they can pay only the amount which is paid. Till then only, my lord. Of course, in some of the orders, my lords have specifically told my lords and directed that it's the fees which we have paid, my lord. In some cases, not there. Because of that, what's happening in many cases, my lord, so banks they are approaching. Banks would say what the college says. Then colleges, some colleges have not received any fees. They are grateful to some colleges. They are not received any fees. No, only fees, my lord. Only one sentence, my lord, that may kindly, my lord, come from this one. Because the till my lord decides the fees which we have paid earlier may kindly be received by the college. That also will maybe this.
Already on record, we don't want to do, we'll list it after 2 years. But even if you can, report some kind of an understanding from this, we can just record. them.
My lords, in the.
Not decide on what.
Yes, my lords, may I request my lords, because there are so many colleges which have not come forward as yet, and they have not objected. Those admissions may be confirmed in those colleges, my lords.
Absolutely. Those who have, as a matter of fact, place to consider, we consider on the list.
Work it.
17 to.
Yes, my lords, I appeal for the petition.
B group, number
Lots.
70.
In this, I was required to take instructions in the matter, my lords, regarding the virtual vacancies in the second round. Only that was the issue, my lords. My lords, may I place the NMC rules with respect to the virtual vacancy, my lords? It is come into force only this year, as per my instructions. So may I kindly take this. There is.
There is. Copy, ma'am.
Second page. Second one. Virtual vacancy. Yes.
However, such seat will be allotted in round 2. Will be allotted from each other.
Yes, this year itself, it has come into force by the NMC. We, my lords, we have our 2006 rules and 2006 Act. We follow that, my lords. And there is nowhere which says that, my lords, may I make? Nowhere it says that we have to follow how the MCC does the allotment. We have our own act and rules which we've been doing it from the year 2011. Not a single instance of, my lords, dilution of transparency. May I place, nowhere, my lords, let them produce a single instance. That is not the case of transparency. That was not transparency at all, my lords. My lords, every round, my lords, we announce the provisional list, we call for objections, and then we allot this. This has been introduced only this year by the MCC, my lords. It is not that they've been following it. Now, this year, the second round counseling is over. We have done with it. We have allotted the seats. Second round, my lords. Now we are in the third round. My lords, the third round is going on, my lords.
Are you stating that this is not applicable?
My lords, this is not our rules, my lords. This is the MCC which has adopted this year for this year counseling. No, my lords, this is an extract of MCC counseling, my lords. Just produce how it is. Yes. Yes, they have adopted only this year, my lords. They have not adopted it from long. No, my lords, we are not bound by this, my lords. We are our act and rules. MCC.
Please give us the text. This is applicable. Both the brochure as well as
Our brochure, we've already placed it on record, my lords.
This is the MCC. I have only one copy. MCC.
Yes, my lords. And this year they've adopted it. This year, my lords. Yes, please. Yes, please. Please, that is. Please, I have only one copy, my lords. No, I don't have for the learned judge, my lords. Help. And it's not there in our 2006 and rules. I've already placed the brochure before your lordships, my lords. And here, my lords, very clearly says 2.19. Each round of counseling is a separate round and rules of each round are different. My lords, we have not adopted this. Ours is a single entry, my lords. Entry options we give in the initial state, which cannot be changed at any cost. My lords, in this, in the registration, in this way, my lords, merit is maintained. But whereas in this counseling, my lords, merit cannot be maintained. But where, for example, 1 to 50, and he is allotted, say, 55 in the first round itself, 25. So he can only have options above 25. That is, he can go and upgrade his seat, but he cannot come down. But in this case, a person who is down also, I mean, if he has not opted, then it goes haphazard. So the merit is not followed here, my lords. My lords, I'll explain.
He has a better option. In the second round also, he can participate.
Yes. Yes.
MCC, I understand the contention that this is only in respect of their quota and their.
Yes. Please.
Does not go.
Yes. Why? Because, my lords, may I explain? Why? Because
Yes. My lord.
You have 20 options for it, and you get your 19th option. That does not mean that you cannot upgrade to your 18th or 17th option. That does not mean that you can opt, if you get the first option in the first round, there is no question of any upgradation. It is,
yes.
if you don't get your first option, then the first, upgradation happens at all. Yes, you get your first option in the first round. Means you are way up there.
Yes.
There will be no upgradation.
Please.
He says that in the first round, if you get your 15th option, that does not mean that in the second round you can opt. That upgradation means anything above what you got.
Above. Our rules is only above, my lords. It cannot go. Yes.
They say that in their all India quota, there can be something, there can be separate registration, separate options.
Option A.
If in the second round there are other colleges available, you can separately register, separately apply. It is not available as far as you are concerned.
Please.
But it is only rearranged.
How do you upgrade if you do not know the seat? It is neither about the petitioner. Forget about the petitioner, if the candidate or not case, it is something for them to, on the basis of their ranking, they'll get or not get. The issue here is only notification of that seat in the seat matrix. That is not answered by this.
Their contention is this, if I understand correctly. Correct me if we are wrong. contention is this, in the second round, first round, the seat is made available. The seat will be a lower option for the candidate. In the second round, they say that automatically by the procedure and by the, if somebody of a higher rank avails the vacated seat, then there is nothing more to notify because that the availment happens in the second round itself. The virtually vacated seat is
Yes.
allotted by the procedure itself and there is nothing.
That is.
But the exercise of upgradation is a conscious exercise. The conscious exercise of rearranging your options. If I do not know that the seat is available, how do I arrange my options for that seat?
They're not in the state quota is there.
My lords,
So there is only one chance.
Yes.
The options. The options are already there.
No, but they have
The
themselves.
options are fed into the software. And if a person vacates a seat in the second round, there is no question of the that being virtually notified at all. Because in the software it says who has an option for that seat.
Yes.
Automatically.
Yes, my lords, may I submit, my lords? In fact, there is a rearrangement of options. That is what a learned friend also said and accepted last time, that option is entered only once. If it is anesthesia first, then I don't get it in the first round. But if I have a chance of getting another seat, another subject like general medicine, which is my 10th or 15th option, I can rearrange and bring it up in the second round.
No.
Yes, they can rearrange, my lords. They can rearrange.
There
That
is a manner
available. My
in
learned friend does not know.
rearrangement. There is a manner, my lords.
No, my lords.
No, may I submit how it is rearranged?
I am
Say the
complete.
person is, candidate has got 25, seat number 25. Above 25, whatever options they have, that they can rearrange, not below 25. Below will go off.
It won't be seen only.
Won't be seen.
It won't be there.
My lords, rearrangement is available. If at all my second option is general medicine, I can bring it up. They rearrange the option. That is what learned friend Ramesh also has said in the, on the last occasion in another case. So rearrangement is permissible, not the fresh entries. So now
Rearrangement.
Above, upgradation.
Option that you have is you have
Yes,
got.
yes,
Or
yes.
yes, if at all the seats are available, I can rearrange. There is no there can be restriction that I should rearrange only this seat which is available. No, my lords, rearrangement is my choice. If at all I get, if at all I bring my probable seat to first or second, then KA will allot based on my rearrangement. They will, if the seat is available, they'll click it. This is what happens. Now, my lords, I will complete my submission. What happens is now in the second round, what they have done. First round, students had, they were allotted, they upgraded for the second round. What my learned friend says, in the second round itself, they are going to allot the seat within the, they have done. Yes, that is where it's, that is what is the problem. Between the first round and second round, there will be a week's time. Then they will have the idea of who is holding the seat and upgrading the for the second round. So this is called virtual round, which MCC is giving. Even they also can give in some other name. These are the seats available because some of the students are upgrading and they may take it, may not take it. So I will have some probable guess so that I can upgrade my seat accordingly. What we are requesting this honorable court is now also, my lords, in the mop-up round, kindly see the affidavit my client is filing, wherein MCC has completed its third round. Their results also have come. Yesterday, till 1 o'clock, the time was given by MCC saying that if any candidate has any discrepancy or any grievance, they have to upload by 1 o'clock yesterday. And after that, the result, seat will be final. Whatever is given, admission is final. Now, since KEA has said today at 1 o'clock, they are going to close option entries for the mop-up round. There are several candidates in the second round they have taken from the KEA. They have again participated in the MCC. They have been allotted there. Now, how the KEA is showing those seats, my lords, because they cannot even leave the seats. Kindly see the, that is the problem, because unless they show, now, I have now, my options are over, by 1 o'clock it is over.
by seeing the seats which are already taken by MCC, that will be confirmed today.
No, my lords, we are announcing only on 29th, not today.
Now, what happens those seats which are now released? My lords, that is one example of that. There are so many such seats. I have
When-
given a copy.
My lords, my learned friend is relying on the earlier calendar of events. We are announcing third list only on
My lords, may
29th
kindly see
after these vacancies come into place and we the allotment counseling is done.
This
So these seats will,
Let.
29th is the announcement of today.
1 o'clock today. Option entries as per the KEA notification.
Today counseling close.
It closes. My lords, may kindly see document number 1 is a notice by MCC. This is after the third round. It is for the information to all the candidates that the provisional result of for third round NEET PG Counseling 2024 is now available. Any discrepancy in the result may immediately be informed to MCC of DGHS up to 12 noon on 26/1/2025, though email, through email or whatever. The candidates were further informed that provisional result is only indicative of in nature and subject to change. The candidates cannot claim as any right over the allotted seat in the provisional result, and the provisional result cannot be challenged before the court of law. The candidates are advised to approach the allotted college institute only after declaration of final result and only after downloading the allotment letter. Now, my lords, I am going to show this. The third round, they have given page number 7, my lords, MCC, allotment procedure, the reservation. Page number 8 may kindly be seen, my lords. MCC gives all second round and third round. Now, all up to third round, they have already declared the results. That is, kindly see, my lords, serial number 2, because for the purposes of this, first one is says not reported in the first round. They have not even come before the taken the seat. Second round, second serial number, page number 8, my lords. Serial number 2 reported. So there is no second round. After second and third round, they have not taken. Like this, my lord, serial number 6 may kindly be seen in this. Reported. Again, they have participated in the second round, reported, and the third one they have not done. That means to say, first one reported, but they participated in the second round. Second round they reported. So there ends the matter because they have not taken the third round. This is how they are giving in one sheet. My lords, may kindly come to page number 9. Now this is a second round allotment of KEA. Kindly see, my lords, this is second round allotment. There is one candidate at a serial number 434, rank number 11,687, allotted in the second round by KEA in ESI Gulbarga, MS Atho, and allotted, seat is allotted. My lords, kindly come to page number now. Page number, document number 6, my lords, page number 12. The same rank number. From top, my lords, 6th column. MCC round, third. Now it is over yesterday. They have given the last time, date and time. 11,687 rank holder also participates in the third round of MCC counseling. And he has taken, my lords, page number 12, my lords, 12. This is MCC allotment of the same candidate in the third round. From top, my lords, 6th column. Rank number is given in the beginning, 11,687. And the seat which is allotted in the under All India quota, Gulbarga Institute of Medical Sciences, Kalburgi, MS Ortho. He has been not reported. Again, he upgraded. Fresh allotment, last column may kindly be seen, my lords.
fresh allotted in the third round of MCC.
Therefore, the census becomes vacant.
In the second round.
In the second,
Third round, last column may kindly be seen. Same, in the same row, last column. In the third round, MCC allots him seat. That is District Hospital Vijaypura, Karnataka.
vacant.
Now this falls vacant. No. Yes, my lords, I'll come to this. This is now allotted by MCC. The candidate either has to take or the candidate or that one.
That one.
This has to be now. Yes. Yes. My lords, that is.
But then the option is common. And if the option is already given, and this seat falls vacant, and is provided to somebody who is already opted, who has a better rank, and who is better in merit, already opted.
No, my lords may kindly. Yes. No, please. My lords may submit.
Yes.
This now, this seat, the candidate has to now decide by today whether the candidate is taking All India quota seat or KEA seat. If All India quota seat is taken, KEA seat becomes vacant. That has to be immediately put it in the seat matrix with the additional supplementary list. Because now I am the third, now my lords, in my category, kindly see my lords. Now my ranking is, I am the only rank holder in my, because above all,
Please, my lords, whenever, if they don't get admitted, it will come to the third round automatically. And it is web hosted. It will be web hosted, my lords.
No.
Please.
No, that is what my lords. Yes.
See what happens. If the list, now they have to decide today whether they are taking the All India seat or the state seat.
Yes.
If they take the All India seat, the seat becomes vacant, it will be web posted.
This, my apprehension. Option entry.
Or it goes to the next round. If the principle is to be followed of transparency and notifying the seat, there is no need for those seats which come in. I'm now giving the example, now giving the situation. These seats get always away, always, like in the first round to second round, what happened? They came always away. That they should be put in the next round and notified. Why? Don't do it virtual. Don't do it virtual. But notify it next round, like you'll be doing it this time again. So
my lords,
this is the requirement of transparency. So that every time, after all, you're having so many rounds for what purpose?
We understand, and as long as they don't object, they're saying that it will be put up. Those seats which are made available will be put up before the option entry closing for the mop-up.
Today, my lords, at 1 o'clock, option entry for mop-up is closing. No, my lords, kindly, I may be permitted to complete my submission. Today at 1 o'clock, option entry closes. There are so many seats yet to come back to KEA for the mop-up round. If they are not notified, because I am the next now candidate, a meritorious candidate, because above me, they all have taken already seats. Now I am going to lose the option entry also. Therefore, option entry has to be extended, my lords. That's my submission.
Or stay your hand. Don't automatically put it into the system when nobody gets to know about it. Put it in the next round after we're hosting.
My lords, that seat, in case if the person and candidate does not come and admit, then that seat goes to stray vacancy. My lords, the brochure has been submitted in the serial number.
All India brochure, page 35 is important. 35 and 36. Yes. There also there is an stray vacancy.
No, if that is not what they say. If the seat which has been allotted in the
second,
if that is All India quota seat.
Yes.
No, my
Goes
lords,
to stray
All
vacancy.
India quota seat he has already chosen. He may take it.
No,
If he doesn't take it, my lords, my contention is not that.
5th February, 5th February. 5th February 2025. Please. Everything.
My lords,
There is no. So I just say this much. Let me not say. Without first posting it in a systematic, whichever route. If it all
This
fails,
year it can't be done, my lords. My lords, it's over.
This is what I.
This
When
is,
four
my
rounds
lords,
are
when
there,
the,
vacancy round is coming, still they say they cannot notify it for transparency. I can't understand.
how is NMC concerned, my lords? Let.
Yes.
Why?
TMF, my lord, we record it. TMFI Foundation says it shall be on transparency, it's a constitutional.
Lords,
bench judgment.
let them demonstrate one instance of
I
not
will
being
produce
it
the
transparency, my
national
lords, from the year 2011. Lords, this KEA, my lords, not only medical seats, all seats, all employment, everything is done by KEA, my lords.
Say that extent that no seats shall be notified, shall be offered for allotment without notifying it in the next stream, in the next round whatsoever, by putting it in the seat matrix. What is wrong with that transparency? I fail to understand that.
My lords, our act is intact, our rules are intact, our brochure is intact, my lords. And we are following the brochure in every step, and they're not able to demonstrate one case where there is
I have
no
already-
transparency.
Last year, with regard to.
Lords, and this is going beyond the scope of the writ petition. Lords, how can they expand the scope of the writ petition, my lords?
My lords, it is not expanding. There is no such law even in
Lords,
PDT rules
their
also.
case
My lords,
was
let
that
my
the
learned
seat
friend
was
come up
not
with all
allotted
these,
to them. They are not
specious
eligible
contentions.
as per round 1, round 2.
She has taken now this suspicious contention that it is there in the law. There is nothing in the law that forbids the KEA disclosing the seats.
They are exposed to say that. Get an instruction from. Possibility of putting in the available system. That expect at least to ascertain some.
Obliged, my lords. 2:30, my lords. May I pray for 2:30 minutes? Okay.
Okay.
Court officer. Court officer.
Continuation, orders, till number 18. Meenakshi K notation.
Appearing for appellant, my lords. I'll take fresh steps for the answered respondents. I'll be implementing the LRs, my lords. A short accommodation may be given.
Earlier, in this case, the appellant in this case was a party. This suppressing both sides because disclosing the facts of the Habeas. I filed application in the year April 2019. They are not taking steps under these circumstances. They could have taken steps for publication. 3 times are over for other things also.
Not audible, my lord.
Switch on your mic, he is unable to hear you, what you are saying.
I submit that I made an application invoking section 11 of the CPC contending that this appeal is not maintainable, my lord, because this matter has been disposed of by this court in the earlier proceedings that I have also produced before the judgment. Same person, Vijay Kumar himself was a party, is the LR of his father, who contended that with regards to the same property wherein he sought for 1/3 share, that has been dismissed. Whereafter they came up before this honorable court. This court has disposed of that matter. That copy I have also produced, my lord.
Arguing time. In the meanwhile, this question of maintainability, you have to argue. Are you ready?
My lords, with regard to
I'm sorry.
Ah.
Counsel, are you ready to argue the matter on maintainability?
no, my lords, a short date may be given, my lords.
We'll give you time, but in the meanwhile, please get ready to reply on the maintainability issue.
Okay, my lords.
They have not chosen to file the written statement. And
Against the same judgment, this appeal.
yes, not same judgment, same subject matter was filed, again executed as original suit. And again, they have brought up before the court, we have produced. No, I was not a party to you, my lord. It is
one of the issues then.
your lordship can see how well disposing of my application. No, as I was not a party, the written in the body of the judgment, it has come. But it
You're
is not.
saying that on the very same subject matter, not from the very same judgment and decree.
No, not very same judgment and decree. It is on the same subject matter.
Yes.
The
Please
same
take
party.
steps immediately.
Much obliged, my lord.
Yes, 2 weeks left.
Much obliged.
K. Sanat Kumar Shetty.
Second time notice to R4. Yes. 2 weeks left.
20. K.S. Ramesh. Copy not served to other paper.
2 weeks time will be.
21, tested.
List for final. List for final. Non-participation list for final.
Prepare for respondent, madam.
Week's time.
But appellant has to do it, madam. Fine.
22, Gita Devi MP. 23, T Jagdish.
Third time after recalling. This was the matter, he was present in the morning. He had sought time in the morning.
Week's time.
Hmm.
Request week's time is granted to.
24, Girish Kodgi.
Synopsis was delivered handed over to Mallikarjuna, clerk of Pradesh Sarkar on that day, on 9th itself.
What is acknowledgement for that? What is your lawyer? You make a request to somebody, you can't enter like that only. It's not a market where you can come and say whatever comes in your mind. Your lawyer should come. There is no representation from the appellant. Week's time is granted to do the needful. It's not a market wherever, whoever comes, we don't know who are you. Ask your lawyer to come. We don't know, sir. Ask your lawyer to come.
25,
Appellant. Respondent was directed. Mistake. Respondent was directed to find an affidavit. Actually, it's not.
What affidavit?
What happened, my lord? I was disposed in the year 2009. Then a petition was filed before the High Court and also before the Human Rights Commission. Human Rights Commission ordered to restore the possession because I was disposed without due process of law. Then the High Court directed to file a writ petition subsequently if they are not delivered.
So also BBMP shall get specific instructions as to where the appellants are to be accommodated and affidavit shall be placed on record.
Yes.
BBMP,
Yes, my lord.
yes,
BBMP not come.
it is to the, as to where the appellants are to be accommodated.
Accommodate. Rush vacancy, we have been dispossessed. Nearly 30 people have been dispossessed. Writ petition was filed, even a Human Rights Commission was filed. Now they say you go to second court trial court, the writ petition, it is indicated that just like
Person from market. What is this?
dispossessed from a building which is owned by BBMP. Near the Kalasipale bus stop. Now they wanted to accommodate in a different way. That's why this appeal was filed.
And where are they? Where is the BBMP?
It's a last chance. 10 days time is beneficial. Comply the order dated 2/12/2024.
Date and time.
17-2.
You just convey to.
Much of.
26, Sangamesh RB.
R3.
1015 days.
Take steps by
Filing delay. Substituted service to R3.
Yes, madam. We take a paper
Three
public.
times, when you will take.
I thought to take on me.
Huh?
I already taken, 3 times I've taken.
That is the reason, because just come back, your lock, you have to take substitute service.
Yes, madam.
When you will take.
ಅಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ ಆಲ್ರೆಡಿ ಫೈಲ್ ಹಾಕಿದ ಅಪ್ಲಿಕೇಶನ್
ಇಲ್ಲಿದೆ.
22/1/2025 ಫೈಲ್
22/1.
22 ಫಸ್ಟ್
Paper publication.
ಪೇಪರ್ ಪಬ್ಲಿಕ್ ಅಲ್ಲ ಅಪ್ಲಿಕೇಶನ್
ಏನ್ application ಹಾಕಿದ್ರು?
Paper publish. What is that?
22nd.
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 Third, is the ordinance made in the ordinance made in the IFC. Take notice on respond number 3 by way of simple service. By way of paper publication. It shall be published in the daily newspaper, Indian Express, on or before
18/2.
indicating the appearance date as
11/3.
11/3.
Much of
Collect this later.
Yes.
Let it be there.
Okay.
Twenty-seven.
Paper appellate. Pressed and complying for 1 week. Today gave to me my client death certificate.
28. 28, Manjunath Prasadvi.
A week time may be granted, Mr. Lordships. Grateful.
Possibility.
Grateful.
29, urgent. 30. Radhanandan PS.
1 week matter. Office objection has been complied with. Only regarding limitation. So, new act, I'm the appeal. New act or old act? It's a new act.
How many days delay?
Past over, only court fee issue is to be addressed.
Can you comply then?
In that matter, I had already, in another matter, I had convinced my lords that it is only in interest. That is not reject, that there is an order. I'll pass it on. File is with my colleague, I'm sorry.
Second set ಇಲ್ಲ ಅಂದ್ರೆ ನೋಡಿ ಎಲ್ಲ ಮಾಡಿ weeks time only first set you apply second set ಕೊಡಿ appeal memo
Second settle,
weeks time is granted
1 week.
comply out.
31. Veeresh Pudiyal.
Pay for 10 days time, please, Milord.
32. Dilip CG.
Not for the petition. We had filed this application seeking extension of time and not because of that.
What is the office objection?
A prayer, 3 prayers. 3 prayers, my lord. They're actually 1 prayer broken into 3 parts.
Which is the IA? 1 of 25. 1 of 25.
Two weeks time is enough, sir.
Yes, consider admissions together. Yes, but on merits, we have to hear it.
I'm the first respondent.
Yes.
And interim order was passed on 28/11/2024. The same day, the second appeal was dismissed.
What has happened, my lord? My lord is pleased to recall, my lord is pleased to hear the matter. The interim order was passed on ink page 17 on 28th November 24, based on a submission by the learned counsel for the respondent, saying that they will admit up to 42 students. Same day, they passed an order. On the same day, my lord, probably the central government is not aware of the stance taken by the NCISM. They passed an order, which my learned friend has filed on an memo.
And what actually happened? Was the, were the seats included in the seat matrix at all? No.
No, my lord, not that. The impugned order, my lord, what we had filed before, my lord, the writ petition.
These are seats.
Yes.
These
this
are
is now, my lord,
issues with regard to the
Seats.
permission
permission
for the current year.
for the current year.
What happened in the admission?
My lord,
Were the
38
seats
students have
considered?
been admitted
How?
pursuant to the order of my lord.
Through the KEA?
Yes,
Okay.
yes. What happened, my lord, we have not been able to admit 4 students. 4 students. Time was extended, my lord is pleased to say in page 24, on 8/1/25, time was extended up to 13/1/25 for another 5 days from 8/1/25 in page 24, my lord. We have filed this interim application requesting, my lord, extension of time by another 2 weeks to admit the 4 students, my lord. That's all we are seeking. The cutoff date was 13/1/25. Because. Please, my lord.
May it please the Honorable Court.
Yes, yes. My lord, we have filed a representation on 9/1/25 at in page 25 seeking, because we have come belatedly into the scheme pursuant to the order of my lords. My lord was.
You
pleased to
filed
pass-
the application before the appellate authority of the NCISM as also before the central government
Yes.
in
yes,
appeal.
Yes.
And you created this issue.
My lord,
Because one appeal was allowed.
They
one
filed the
appeal was
writ
rejected.
petition, Your
we
Ladyship.
filed the writ petition
Ah,
impugning the order passed by the NCISM.
I understand.
Yes.
But in the meanwhile, how did this
We had
other?
also filed, my lord, we had also filed. Where is the writ petition? Which paragraph is mentioned? Writ petition.
That was allowed, which is why we gave that implement.
Where is the paragraph?
In the meanwhile,
I'm sure.
they have gone in the field because the government also- it was-
They have corrected and
They have corrected, but in the
Yes.
meanwhile, they went in appeal before the government also and got an adverse order,
Please,
he
ma'am.
himself has gone to an appeal.
correct?
Yes.
Before the central
Withdrawn
government,
the appeal.
Yes.
as simple as
Withdrawn the
that,
appeal, no?
if that.
My lord,
You have withdrawn the appeal.
my lord, it was on the same day. What happened, my lord, when my lord was pleased to hear it? On the same day, the central government in the afternoon, on instructions, made a submission.
Now, how can
That-
how can
No.
my friend say that it is in the afternoon? An order
was-
was passed in the morning.
No, no, it
and
was
after-
passed over to the afternoon, my lord, please recall.
Whatever happened,
Yes, ma'am.
there were two orders, you had approached both the authorities,
Yes.
there are two conflicting orders now.
Yes, ma'am. And,
Which prevails?
my lord, the 2811, again, NCISM has passed a fresh order in line with the directions of my lord.
Where is that order?
But what
Here
order
it is,
provides?
20, you just said. Page number.
That is only a consequential order.
No, no, same day, my lord. Where's that order? 2811.
Here it is,
Which is that order?
Yes, sir. Get it?
2811, no?
2811. They have.
2811.
They have produced on.
Yes, that is there.
It's the order of the NCISM.
Hmm.
They had submitted before the honorable court and they passed the order on 2811.
Hmm.
Same day, unaware of the order passed on 2811, based on the earlier order, the central government passed an order on 2811 based on the earlier order of rejection, which is impugned before this honorable court.
You filed two appeals.
We filed only one appeal, my lord, before the.
NCSM.
Yes, my lord is right. Two appeals.
Basically, that is what created this issue. Now, we filed two appeals. Now what do we do?
My lord, the central government will have to update, my learned friend.
The
will have
lordship
to
may
update.
pass some orders to direct them to. Yes.
Send your report.
Hmm.
Can consider.
Which paragraph it's mentioned there? Yes.
You would have filled up those 4 seats. Why you are waiting now?
Please, my lord.
4 seats, 1 seat is extended, no? 13th January it is extended. You would have filled that seat. By 30th January, you would have filled 4 remaining seats. Why you are not?
My lord, we were not able to, my lord. No, only 4 seats, my lord. These 4 seats come within the management quota, my lord, and the NRI quota. My lord, we all were requesting, it was extended for 5 days. All we are saying is 2 weeks' time, my lord. Because these 4 seats, what has happened, my lord, is pleased to see.
Can we extend that time?
My lord, they have been.
That issue is covered by a division bench judgment, Your Ladyship and Lordship, against the petitioner. There can be no extensions. And the division bench has relied upon a Supreme Court judgment. My colleague is in court and I request her to hand over the judgments.
I'll just
So
go through
there
it,
are
my lord.
two.
Please have it tomorrow, my lord.
Please tell us whether, if we cannot do it, we cannot do it.
No, I'll just go through the
At least,
judgment.
at least you got 38.
Because of interim order, you have.
No, no, my lord, I'll just have it tomorrow, my lord. I'll just go through. I'll just go through the judge.
List it on some, tomorrow or day after. Tomorrow or day after we list. it.
Grateful.
Grateful.
No, that is because it stands modified. 33.
I appear for the petitioner in this matter, your lordship.
Correct.
Lordship, I appear on behalf of the counsel for R2,
We have mentioned.
who undertakes to
We
file.
have mentioned it. We have mentioned it.
Moment, please.
We have mentioned. No, we've got the amendment application. We'll file that also.
Yes,
Yes. We'll file that today itself.
yes, let's see. Yes, item 33.
Lords,
I
I
appear
appear
for the petitioner in this matter.
counsel for R2, my lords. One Mr. Nidhi Patil undertakes to file wakalat for R2, my lords.
Item 33. What about R3?
I will take fresh steps, your lordship. I will take it during the course of the day.
Yes.
The interim order may be extended, your lordship.
Registry shall show his name in the past list and is permitted to file wakalat agreement from 1 week, 2 weeks. A week's time is when take steps to respond number 2.
Obliged.
Interim order.
Interim order granted earlier is extended.
34. Satyarthi.
Appearing for the petitioners, my lords, I have served 3 and 4. Respondent number 3 and 4 are the standing councils, learned council number.
Respondent number 3 and 4 cannot be standing council. Respondents number 3 and 4 are.
I've served on their standing councils,
Yes.
my lord. 3
That's a
on,
better submission. 3 and 4.
KEA Karnataka Education Authority and Rajiv Gandhi University.
Whom you have served?
Ramesh, NK, Learned Council Ramesh NK for KEA and Farah, Learned Council Farah Fatima for Rajiv Gandhi University. My lord.
Let's see, serve the copy. Ramesh. Okay, as the council is responding number 2. Farah Fatima, council for responding number 2. Their name in the past list.
But this matter pertains to charging of excessive fees.
Hmm.
The college is a necessary party in this.
College is also R5.
Yes, Tarun.
Served.
They are necessary,
They served. They're on record.
5 and
Served
6.
also.
represented me.
Notice served. What can we do? If they're not unrepresented, I mean, they don't want to represent themselves, what can we do? Yes.
Like there are a lot of discrepancies in the amounts they've charged. But in the amounts they've charged to each person, they're comparatively.
Different amounts for each person.
Based on whether they are government seat or private seat, there's a discrepancy. Like government seat, they are charged slightly lesser, for private seat slightly more excess. So I've made a tabular column. It's available in the petition.
Let's see. Please, sir, now 3 and 4, let their names be shown as well. Let's
Passed over matter. List 2, seal number 1, Anushri, sorry. Seal number 2, Anu Parnadi.
Respondent statement.
Name petition.
For grounds under the act, not taken up.
Now it's in the writ petition. I
But-
think earlier writ petition, some changes were made.
Yes.
Grounds for a preventive
Lacking
detention
are-
writ petition are obviously lacking.
All grounds, what you could taken, that is not found.
This is like a normal writ petition that it has been drafted. It appears that the proper grounds for a habeas corpus writ petition under preventive detention does not appear to have been taken.
Initially, what they said was,
They only sought for writ of certiorari. I made a oral submission that habeas corpus also we have to seek.
Correct.
So the original grounds related to only the quashing, but in a writ of proceedings of habeas corpus,
He can
these
consider,
issues may not assume much
he can
importance.
consider even without the
Yes,
specific,
that
but
is
then
what-
they'll not be able to reply. That is a difficulty. Unless these grounds are taken, how do they?
the grounds are not there is what your lordship.
Grounds in your writ petition.
Huh? What?
Grounds in your writ petitions are not there to take the order of.
Grounds for certiorari is there, not for illegal detention.
Not
Please,
for,
the
not
habeas
for
corpus.
preventive detention.
Subjective satisfaction, excess of the cases, what they have relied, long old cases. they have
Another
not
thing
used.
is, now, my lord, the matter has placed before the advisory board, or I came before the court, even before the advisory board has heard the matter. Should I wait or straight away argue the matter is another issue.
I think the,
Because his right of
Because
representation is
there
being
is-
considered there.
correct.
There is one more line of argument is even pre-detention also court can interfere. On merits, my lord, there are only,
Pre-detention, if at that stage
yes,
stands vitiated, of course, we can
yes.
intervene.
In this case, out of 4 grounds,
Hmm.
out of 4 cases they refer to,
Two are outside the jurisdiction.
2 are outside and they are also not under this one, suppression of immoral traffic. They are IPC offences. 2 are, one is January 23, another is January 24. Detention order passed in December 24. The Supreme Court in identical circumstance, 7 months plus, they said it is too distant a period. And they also say, no, no, you violated bail conditions, and these are the main issue that is there. And another is, does it amount to every breach of every illegal act does not amount to breach of public order. These are the issues. Well, if I have to file it, I can file an additional affidavit.
That will do. That will do. We can wait till if the,
So initially they had sought for writ of certiorari. That is how.
as a matter of fact, if these contentions are accepted by the advisory boards,
Yeah.
that would be the end of the matter. We cannot assume that it will not be accepted. So shall we wait?
Should, when is the, I don't know, now they say advisory board has heard the matter.
Reserved for judgment.
It-
Reserved
it's a-
for report. Report.
Opinion.
Yes, opinion of the.
Let's wait for 2 weeks. And in the meanwhile, if
1
it,
week, my lord, your lordship may call it next week.
After that, if it is not ready, Lord.
My instructing counsel has great urgency, so it's not.
we understand the urgency. If the preventive detention order is not legal on any count. there is
Next
an
week, my lord,
urgency,
if there is
because
any,
there's an urgency for the court also to see that the person is released at the earliest, if there is any illegality.
in the meanwhile, I'll file an additional affidavit raising additional grounds too.
Otherwise, it may not be possible for them to anticipate what the grounds are. It's only at the hearing that they will be confronted.
Huh? ಇಲ್ಲ, ಬೇಡ ಈಗ.
Next, after a week. 6 to
6 to next week, huh? Very well.
List 1. Till number 3, government advocate.
The writ appeal is dismissed only on the ground of delay, my lord. It may be kindly condone, madam. We have merits on case. If there is a delay of 597 days, state appeal to secure the instructions and to get the order. We have explained in detail why the delay has been.
after it has been dismissed by a coordinate bench.
Please, my lord.
On the ground of delay, after considering everything, your affidavit is extracted. On a reading of the same, it is to be
Yes, ma'am.
noted that the affidavit very cryptically seeks to explain steps taken between 5/7/2018
Please, my lord.
and 15/1/2021. Inasmuch as matter was considered at the government level, decision taken to file an appeal on 15/1/21.
Yes, ma'am.
It is only after an unexplained delay and by only stating that there are more than 100 petitions filed by several petitioners
Yes,
and
ma'am.
that writ appeal involved huge paperwork. All the other matters were filed without delay. Why only this writ appeal involves paperwork?
Need,
Everything was filed without delay.
please, my lord. The-
What is the
to-
paperwork involved in this case?
To gather all the materials and to get this.
They had already been
Yes, my lord.
admitted at that time. When you file this appeal,
Only
the
this.
100 writ appeals are already filed and pending.
Read petitions, my lord.
Absolutely nothing wrong.
It may be condoned only on that ground, my lord.
He cannot, what we'll say is, the bench has also specifically said that the question of law is left open. What is the error that requires a consideration? Everything is considered. Every word that you have stated in your IA for condonation, the relevant portion has been extracted. It is found that no reasons have been stated. What is the error in that? If reasons are not given, why should the court condone?
By batch matters.
That is also taken care of.
Yes, ma'am.
This review petition is filed seeking a review of the judgment in writ appeal number 63 of 2021. First, heard the learned AGA appearing for the review petition. It is contended by the learned AGA that the writ petition came to be allowed by judgment dated
5/7.
allowed by judgment
18.
dated
5/7/2018, my lord.
17
5/7/2018.
5/7/2000
18.
5/7/2018. It is submitted that the writ petition was part of a batch of nearly 100 writ petitions, and that as such, there occurred some delay in filing the appeal. It is therefore contended that since appeals are pending in all the other matters, the judgment may be reviewed and the delay condoned so that the matter can be considered along with the connected cases. We notice that the contention that there was proper explanation for the delay and that there are several other appeals pending had all been raised before the bench, and that the aspects have been specifically considered as well. The reason stated by the appellant seeking a continuation of the delay of 597 days was specifically considered by the bench, and it was found that there was absolutely no reason stated for condoning the delay of 597 days. It was also noticed that the connected matters had been filed without delay and had been admitted by a co-equal bench of the court without any delay having been occasioned. It was after considering these aspects and referring to the case law on the point of explanation as to delay that the bench was pleased to dismiss the appeal on delay. Though the learned AGA submits that the delay is to be condoned and the matter heard along with the connected cases, absolutely no reason whatsoever has been stated to justify an interference with the judgment under review in the review jurisdiction. No error apparent on the face of the record or any error at all has been pointed out. We also notice that the dismissal of the appeal is limited to the parties to the appeal alone, and the questions of law have been left open to be decided in the back of the appeals. We find absolutely no error of jurisdiction or error apparent on the face of the record for reviewing the judgment. The review petition therefore fails, same is accordingly dismissed. Leaving open the question of law to be decided in the appropriate proceedings. This will govern all parties to this. We'll have to probably implement it as far as this person is concerned.
Criminal hearing, syllabus 6, government advocate.
We passed over, my lord. AG is stuck up in some other court. Immediately. Sorry, my lord.
Yes.
Matter relates to forfeiture of EMD,
Hmm.
arising my lords out of a bid, wherein my lords, the respondent here, my lords, was a successful bidder,
Hmm.
but my lords, he refused to enter into the agreement.
Hmm.
So it is a contractual consequence.
Hmm.
The fact that, my lords, it is a contractual consequence is not in dispute.
Hmm.
It is part of the bid document.
Hmm.
That EMD, my lords, was around 11 lakhs.
Hmm.
After he was declared as a successful bidder,
Hmm.
he refused to come forward, my lords, to enter into an agreement.
Hmm.
Now, my lords, earlier when we gave them notices
Hmm.
asking him why he did not enter into an agreement
Hmm.
and asked him to come forward.
Hmm.
Thereafter, my lords, he has given representations.
Hmm.
After considering them, my lords, we had rejected, my lords, his request and forfeited the EMD
Hmm.
and encashed the bank guarantee.
Hmm.
Thereafter, my lords, first round of litigation, he approached this honorable court.
Hmm.
This honorable court felt that we have not considered his representation properly
Hmm.
and set aside the order of forfeiture
Hmm.
and remanded the matter to us.
Hmm.
Now, my lords, at the time of remand,
Hmm.
if my lords may kindly see, the court has directed us to consider.
Hmm.
As against that, my lords, we filed a writ appeal.
Hmm.
In the writ appeal, my lords, court said all the writ petition order said that you consider.
Hmm.
So your appeal itself is frivolous. So therefore, cost was imposed.
Hmm.
And there is a finding, my lords, that no findings as can be recorded. Kindly see the writ appeal order, my lords, which is at page number 99, my lords.
99. Yes.
At para number, at page 102, my lords. At page 102.
Okay, writ appeal. Yes, got it.
My lords have it. My lords.
One more. Yes.
Please, my lords.
It is
It's
unfortunate.
unfortunate.
Hmm.
Please, my lord. It's unfortunate. Middle of the page, my lords.
Hmm.
It's unfortunate this appeal is misconstrued as the government respondents cannot be said to be aggrieved by the order of the learned single judge. As a direction that is given by the learned single judge to consider the representation dated so and so to the writ petition in accordance with law. And the observations made in the order, it's clear from the observations made in the order that the learned single judge has referred and narrated the facts of the case and the facts that certain discrepancy were not to the notice of the appellant herein, and without taking decision on such discrepancies, order is passed. Therefore, appellant could have considered the representation in accordance with law, as no observation has been made by the learned single judge on merits of the case, and direction is issued to consider the representation in accordance with law. So though, my lords, cost has been imposed on us for filing such a writ appeal, but ultimately it is not on the conduct, because in the learned single judge's order,
Not
this
on the merits, but on the conduct of having filed. that.
having filed an appeal, but in the second round, lords, but what happens is in the second round, the fact that my writ appeal is dismissed with cost has been, my lords, interpreted in a slightly different manner, my lords, to non-suit me, my lords, on the merits itself. Now, after this, my lords, a detailed order has been passed. Next page, my lords, page 105. My lords, his contentions, my lords, is twofold.
Hmm.
In his representations, my lords, he says,
Hmm.
number one, there is one more contract that is going on.
Hmm.
There is some delay in those payments.
Hmm.
So therefore, I am seeking for clarification now itself, whether you are going to give me variation. It is in respect, my lords, of a particular structure of a Ghat section, my lords, in Mangalore called Shiradi Ghat, with regard to maintenance, my lords, of a particular national highway. Now, my lords, insofar as works contractors concerned, which are item rate contracts, there will always be a provision for variation and all that. And therefore, my lords, he had given 4 representations. The learned single judge had specifically asked us to consider all 4. And from page 107 onwards, each representation has been referred to separately. Separate reasons have been given. And my lords, we have said why those reasons cannot be considered. And one of the main reasons we give that in the pre-bid meeting, before you bid, you could have raised all these queries, number one. Number two, even whatever you are claiming is already covered with regard to variations under the existing contract itself. So here is a case, my lords, where he bids. After that, maybe he has a second thought. So he goes back. Consequences of the invitation bid document, my lords, has to be given effect to. That is what we have done. Now, my lords, kindly see the order of the learned single judge, which is at page number 18. My lords, at page 23, my lords, is the main reasoning portion. I would go to the extent of saying, my lords, that it is an unreasoned order, my lords, to a certain extent.
Yes.
Page 23, my lords, para 7. It is seen from the impugned order that in spite of petitioner placing the relevant records, including the difficulties that were faced by the petitioner on earlier occasion, wherein the petitioner having carried out additional work to the tune of rupees 1.80 crores from kilometer so-and-so to so-and-so of NH 48 at Shiradi Ghat section, and the refusal by the respondents in paying the petitioner for the additional works carried out, the respondents have mechanically passed the order. I just want to pause here for a moment, my lords. If my order is perused, 4 representations were referred to by the learned single judge. 4 representation, I can take my lords through each of the reasonings. 2-page consideration. Each consideration, my lords, I have said, this is the reason you have given. I cannot consider it for this reason. So this finding, my lords, is contrary to the material on record, is my respectful submission. Then, my lords, the learned single judge takes into consideration the subsequent event, which I would respectfully submit is irrelevant because it is also seen that while the original bid amount of the petitioner for carrying out works at rupees 7.14 as on 4/2/2008, the respondents have awarded the same works along with additional works, kindly note this, my lords, to another agency with additional works for a sum of rupees 13 crores, which was approved on so-and-so. These facts clearly substantiate that the petitioner respondents had accepted the request made by the petitioner. The work should have been completed well within 9 crores or thereabout. I'll just pause here for a moment. Notice if it was their case that by mistake I bid for a lesser amount, and now because of variation in so many rates and other things with regard to the raw materials and with regard to the raw materials, I'm not able to enter into, that is a different thing. But the fact that 2008, this was the contract, 2010, I have awarded to some other person with additional works, without considering what additional works, what was the component of the works, this aspect could not be taken into consideration. Irrelevant consideration is my respectful submission. Then kindly see 8, my lords. Though the respondents have filed statement of objections denying the allegations made by the petitioner, what is conspicuously absent is the reason for declining the request made by the petitioner, contrary to the material on record. Detailed reasons are there, my lords. 9. Taking the totality of the facts and circumstances of the case into consideration, this court is of the opinion that the action of the respondents in forfeiting the earnest money amount tendered by the petitioner is arbitrary and not for any fault on the part of the petitioner. The petition therefore deserves to be allowed and is accordingly allowed. The impugned order dated so-and-so at annexure so-and-so therefore stands quashed. The respondents are directed to forthwith return the earnest money deposit amount of rupees 11,55,000 to the petitioner. Now, my lords, in the paragraph number 9, it specifically says that this court is of the opinion that the action of the respondents in forfeiting the earnest money deposit is arbitrary. Now, kindly see the bid document. Bid document itself, my lords, provides for a consequence. Now, my lords, bid document, my lords, it is, I think, in volume number 2.
Page?
My lords, page number 178, my lords. I'm referring to it starts at page 154 at 178.
Yes.
My lords, I'm sorry, my lords. My lords can only see 171, my lords. I'm sorry. A bid security, 16 minutes, clause 16, bid security. The bidder shall furnish as part of his bid a bid security in the amount as specified and shown in column 4 of the table of the IFB for this particular work. This bid security shall be in favor of the employer as named in the appendix and may be in any of the following forms. I'll just skip, my lords, ABCD. They have given bank guarantees, my lords. 16.2. Also, 16.2, bank guarantees and other instruments having fixed validity issued as surety for the bid shall be valid for 45 days beyond the validity of the bid. 0.3 minutes. Any bid not accompanied by any acceptable bid security and not secured as indicated in so-and-so shall be rejected by the employer and non-responsive. 16.4 may kindly be seen. The bid security of unsuccessful bidders will be returned within 28 days of the end of the bid validity period specified in subclause 15.1. 16.5. The bid security of the successful bidder will be discharged when the bidder has signed the agreement and furnished the required performance security. 16.6. The bid security may be forfeited if the bidder withdraws the bid after bid opening during the period of bid validity, if the bidder does not accept the correction of the bid price pursuant to clause 27, In case of a successful bidder, if the bidder fails within the specified time limit to sign the agreement or furnish the required performance security.
Yes.
Now 34, my lords, also is relevant.
Page 178.
Page 178. My lords, 34. Immediately after letter of acceptance, he has to give the performance security and then enter into an agreement. Now, my lords, 34 talks about performance security. Within 21 days of the receipt of the letter of acceptance, the successful bidder shall deliver to the employer a performance security in any of the forms given below for an amount equivalent to 5% of the contract price, plus additional security for unbalanced bids in accordance with clause 29.5 of the ITB and clause 52 of the conditions of contract. A bank guarantee in a form given in section 8, certified check. 34.3, I'll just read, my lords. Failure of the successful bidder to comply with the requirements of subclause 13.4 shall constitute sufficient grounds for cancellation of the award and forfeiture of the bid security. Notice what he did was he did not give performance security. He also did not enter into an agreement. So, my lords, my respectful submission is, in terms of the bid document, the consequences of non-entering into an agreement and non-furnishing of performance security has been specified to be forfeiture of earnest money deposit. Now, my lords, after that, he has come up with other reasons. This honorable court directed us to consider. We have considered it. And my lords, the impugned order speaks for itself. Annexure N, page 105. Each of the annexures, my lord, each of the representations has been considered in detail. And reasons also have been given. And they're also covered, my lords, under the variation clause. So therefore, my respectful submission is the interference, my lords, by the learned single judge, my lords, was unjustified in this matter. Now, second point, my lords, is in under the Surface Act also, my lords, there was a similar provision, my lords, for the purpose of EMD. Then, my lords, now, my lords, though Surface Act provides for under Rule 9 provides for a statutory consequence of forfeiture of EMD, then, my lords, the principles of 73 and 74 were also sought to be, my lords, banked upon for the purpose of refund. But the latest judgment, my lords, of the Supreme Court, which has been, lords, this has been followed by a division bench of our honorable court, this honorable court, and my lords, that Shenmugavelu case has been followed. Shenmugavelu case, my lords, is the order of the Supreme Court, my lords, which has also been followed in similar circumstances, my lords, by the division bench, my lords, of this honorable court. So the principles in my respectful submission, my lords, will apply, because forfeiture of EMD, first thing, is said to be not an unjust enrichment, because that is what we have to overcome. Because sometimes it might feel that some amount of theirs is lying with us. Is it not an unjust enrichment? Law is settled, it is not an unjust enrichment. Secondly, my lords, with regard to the fact that, though, my lords, I would go to the extent of saying statutory consequence under Rule 9 of the security rules, and here could be slightly different, but still, my lords, here also we have he has accepted the conditions of the bid document. My lords, I'll just take, my lords, to the para 5, my lords, question. Para 5. The question of entitlement of the petitioners for refund of the earnest money deposit of rupees 3.25 crores was required to be addressed in the light of the operative nature of the rules, nature of Rule 9 of Rules 2002. Then, my lords, that rule is, my lords, extracted in internal page 18, page number 13, 9.5, my lords. I will skip that. Then kindly see page 14, 5.2. The rule contemplates that no sale of immovable property shall take place after expiry of 30 days, and it shall be by way of auction. As per sub-rule 3, upon sale of the immovable property, the purchaser shall on the same day or not later than next working day deposit of 25% towards sale price would be the earnest money deposit. The balance amount as per Rule 4 shall have to be paid within 15 days from the confirmation of sale or within extended time, which shall not be extended within 3 months. As per sub-rule 5, the default in payment of the balance amount as contemplated in Rule 5 shall result in forfeiture of security deposit, and the property shall be liable to be resold, and the defaulting purchaser shall forfeiture all claims to the property. Now, my lords, para 5.5, recent judgment is considered. Because there were other views, my lords, also. Now, the recent judgment of the Supreme Court in Authorized Officer Central Bank of India versus Shenmugavelu leaves no room of doubt about the mandatory application of Rule 9.5 of the 2002 rules. The Supreme Court clarified the law and the applicability of the rule in extenso to set aside the judgment of the High Court with directed refund of the earnest money amount. Then, my lords, 2, my lords, 5.5.2.
Yes.
The High Court held that Rule 9(5) of the rules should yield to the principles of Section 73 of the Indian Contract Act. A further view was taken by the High Court that the forfeiture of the amount of deposit by secured creditor under Surface Act cannot be more than the loss or damage suffered by it, and that Rule 9(5) cannot override the ethos of Section 73 of the Contract Act. Next parameters. The Supreme Court held that Rule 9(5) cannot be regarded as penal provision. Therefore, provisions of 73 and 74 of the Contract Act will have no application to forfeiture of earnest money deposit of the successful auction purchaser for its failure in depositing the balance consideration within statutory period. The consequence of forfeiture, it was held, was on account of operation of statutory provision. Then, my lords, I'll read 5.5.5, my lords, same page. It was held that the legislature consciously provided for only one consequence in the event of failure of auction purchaser in depositing the balance amount, that is forfeiture, and any other stipulation is not imposed in the event of breach. Now, my lords, next page, para 18, page 18, my lords, 5.5.6, holding that the provisions of the Contract Act would not be brought into play to negate the mandatory effect of forfeiture of earnest money deposit under the rule, it was observed. If Section 73 and 74 respectively of the contract are interpreted so as to be made applicable to the breach in payment of balance amount by successful auction purchaser, it will lead to a chilling effect in the following ways. First, it would be quite preposterous to suggest that in an auction, which is a process meant for recovery of debt due to default of the borrower, the balance amount, if not paid by the successful auction purchaser, another recovery proceedings would have to be initiated by the secured creditor in terms of Section 73 and 74 of the Contract Act to recoup the loss and expenditure occasioned by the defaulting successful auction purchaser. Secondly, such an interpretation would allow unscrupulous borrowers being hands in glove with the auction purchasers to use subversive method to participate in auction only to not pay the balance amount at the very end and escape relatively unscathed under the guise of Section 73 and 74 of the Contract Act, thereby gaming the entire auction process and leaving any possibility of recoveries under the Surface Act at naught. My lords, 5.5.8, my lords. It was emphasized that the forfeiture was not penal and that there is a difference between the forfeiture of any amount and the forfeiture of earnest money. Whether a forfeiture clause is penal in nature must be decided in the specific setting of a statute. Since Rule 9 Subrule 5 of 2002 rules provides for forfeiture only the earnest money deposit of the successful auction purchaser, that is only 25% of the total amount, by no stretch of imagination can it be regarded as a penal clause, and as such, Section 73 and 74 of the Contract Act will have no application. Then, my lords, para 6.2, in that case, my lords, it was applied. In the facts of the case, no special circumstance exists which would justify the demand of return of earnest money by the petitioner. There is no unjust enrichment on the part of the bank. When the petitioner bidder failed to deposit the balance amount within the statutory period despite having granted extension, the forfeiture of earnest money deposit was a statutory consequence. Now, my lords, I understand the fact that, my lords, that this was under the provisions of the surface rules. But kindly, my lords, see, the principle underlying, my lords, is the same. In so far as even in respect of contracts of this nature, which run into more than 5 crores and which run into crores of rupees, the fact that it could be gamed also, my lords, has been taken into consideration.
Yes.
So, my lords, in view, in that view of the matter, my lords, my respectful submission is, my lords, the order has to be set aside.
My lord, I may be given a week's time to file my objections. Return objections are not filed. This is, I have received this Supreme Court order only now. Give me a week's time, I will.
No objections, you have to argue.
It's a writ
For what objection you have? No objection. Writ appeal, you can't file objection. You have to argue. It's argued.
I'm ready to argue, but if you want, I can, yeah. I'll argue. I request your good lordship to go to the dates, certain dates I want to bring to knowledge. One is in the writ appeal, page number 41. That is the date on which page number 41, my lord.
You're ready to argue the matter on merits?
Yes, yes, ma'am.
Yes.
That is the date on which the tender was called, 7/12/2007. That means the estimate they would have done in the month of October, November 2007, they would have done the estimate. The acceptance was given to me on 19/7/2008. That is at page number 69.
going to be coming down with the cold. Going to be coming down with the cold. To change this temperature.
I'll just read out my
19/7/2008. That is a. That's also good. Oh, I will get the paper. I will get the paper. It must have been there.
Trying to see page number 69, ma'am.
Hmm.
So the date of bid was 7/12/2007, and the acceptance was on 19/7/2008. So there was a gap of almost 8 months. So before that, before the acceptance was given to me, I had given early warning in my letter dated 30th June 2008. That is at page number 53. 53 and typed copies in 54. In the said letter, I had indicated that due to monsoon, the work was in Shiradi Ghat, the Western Ghats area. Due to monsoon, there is likely that the road would damage, and you have to give me the additional incremental value. The early warning is provided under the bid document itself. That's at page number 202, second volume. So 32.1. Early warning is provided. I read out. The contractor is to warn the engineer at the earliest opportunity of likely future events or circumstances that may adversely affect the quality of the work, increase the contract price, or delay the execution of works. The engineer may require the contractor to provide an estimate of the expected effect of the future event or circumstances on the contract price and completion date. The estimate is to be provided by the contractor as soon as reasonably possible. So the early warning itself is provided under the page number 202, second volume. Page number 202, class number 32. 32. That is conditions of contract. The condition says at the earliest opportunity, I have to give early warning. So before the acceptance was given to me on July 2008, I had given an early warning letter dated 30th June 2008 itself, which was not considered. When the acceptance was given to me in the month of July, I cannot carry out the work because of the monsoon. So I will have to wait till October. November only the rain stops in Western Ghats. So I will have to wait till November. The estimate was done previous year, October, November. The bid was in December 2007, and the acceptance was given to me in July 2008. And I have to carry out the work in the month of November 2008. How can the road sustain the condition of the road? It cannot be as it was in the month of November 2007. So because of that, I had to give the early warning letters. Then this was not replied to me. Early warning letters were not replied. On the orders of the single judge, they have no doubt issued another forfeiture order. A detailed forfeiture order was passed, taking into consideration all my representations, but no opportunity was given to me in this. The appeal says in para number 23 of the appeal, read out, in compliance of the order passed by this honorable court in the petition number 14091/2008, there is para number 22. Page number 16. It says, in compliance of the order passed by the Honorable Court in WP number so and so, the respondent number 1 herein was afforded an opportunity of hearing, and the impugned order at annexure N came to be passed by considering all the conditions stipulated under the tender documents. If you can kindly go to the order passed in annexure N, page number 105, nowhere it says an opportunity was given to me. Page number 105 to 1013, 1014, 105 to 104. That was the order passed by them, taking my all representations into consideration and passing a judgment on that. And for again, the second forfeiture order passed by them. Nowhere in the order it says that I was given an opportunity of hearing, whereas the statement made by them in the appeal says that opportunity was given to the respondent, which is not true.
Directed to view.
No, but what I mean?
Clear rounds, single judge and division bench has not directed to provide opportunity.
Only consider.
No opportunity was given to.
There was very direct.
Opportunity of hearing was not given. That's what they say. Opportunity of hearing.
No direction to give opportunity.
But they say but in the appeal they make a statement. The opportunity was had they given me an opportunity of hearing, I would have made a case. I request you to take the timeline into consideration. From November, estimation was done in November 2007, and I was given the acceptance in July 2008. Then I cannot carry out the work. I have to wait till October end. Then I have to carry out the work in November 2008. How can the roads, the condition of the road will remain same? I will have to make a representation. Accordingly, I made a representation. And early warning is provided under the conditions.
PDTP Act.
Please, my lords.
PDTP Act. PDTP Act. No?
Please, my lords. My lords, this was a bid, my lords, that was issued 2007, my lords.
December 2007.
December 2000. KTPP Act, my lords. Transparency.
Karnataka. Document does not say, no?
No, my lords, bid document does not say so.
In similar circumstances, in the earlier occasion, I was denied that amount. Then I had to go to arbitration. I had to go to High Court. Then finally, it was awarded to me.
Bid document starts, my lords, at 154. It does not say so, my lords, that it's under the KTPP Act. It's a standard bid document. It's a national competitive bidding, my lords, in terms of the standard bid documents. But the act is 1999. 99. All it says, it has to be in terms of the tender. Now,
Should be under the PDTP Act.
KTPP Act.
Validity of the bid 180 days.
Please, my lords. Validity of the bid is 180 days. If they finish, I'll give a short rebuttal on that. It was extended. I have an answer.
Delay on your part, no?
Yeah, delay on my part.
It was valid on paper. 13 or something.
No, my lords. Our document itself provides extension of bid validity, and if they don't want to extend without forfeiture, also they can take it back. They extended it. Please.
Argument was.
Then there is another apex court judgment in the issue. There is another apex court judgment on the issue. I just would like to draw. In a similar circumstances, the judgment says, I will just go to the operative portion of the judgment. At the end of the judgment, shall I go to the last paragraph of this? paragraph, last page number, not mentioned here, 53. Page number 53, last paragraph. From a careful perusal of the entire correspondence on the record, we are of the opinion that no concluded bargain had been reached between the parties, as the terms of the standby letter of credit and performance guarantee were not accepted by the respective parties. I had not given my consent to the letter of acceptance. I had not given. Before that, I given an early warning. Then, in the absence of acceptance of the standby letter of credit and performance guarantee by the parties, no enforceable agreement could be said to have come into existence. The correspondence exchanged between the parties shows that there is nothing expressly agreed between the parties, shows that there is nothing expressly agreed between them, and no concluded enforceable and binding agreement came into existence between them. Apart from the correspondence relied upon by the learned single judge of the High Court, the fax messages exchanged between the parties referred to above go to show that the parties were only negotiating and had not arrived at any agreement. There is a vast difference between negotiating a bargain and entering into a binding contract. After negotiation of bargain in the present case, the stage never reached when the negotiations were completed, giving rise to a binding contract. The learned single judge of the High Court was therefore perfectly justified in holding that clause 53 of the charter party relating to arbitration had no existence in the eye of law, because no concluded and binding contract ever came into existence between the parties. The finding recorded by the learned single judge is based on a proper appreciation of evidence on the record and a correct application of the legal principles. We find no merit in this appeal. It fails and is dismissed with cost. In my case, the letter of acceptance was given to me on July 2008. Before that itself, I indicated early warning letter I had given, stating that they would have rejected my, instead of giving a letter of acceptance, they should have rejected my bid. No, you are not eligible for the bid. They would have said that. They did not say. Instead of that, they gave me acceptance of a letter. Then later on, I gave 3 representations. For none of them, there was a reply. Only later, after the single judge gave an order, they passed another forfeiture order. They passed.
Yes.
So, taking all this into consideration, I was eligible for the earnest money deposit along with interest from 2008. Actually, I had paid that amount in 11,55,000 2008. Till date, it is not. I did not realize that amount, and I'm eligible for interest also.
Short rebuttal. Let's page 170. Bid validity. Clause 15, my lords. Bid validity. Bids shall remain valid for a period of not less than 120 days after the deadline date for bid submission specified in clause 20. A bid valid for a shorter period shall be rejected by the employer as non-responsive. In case of discrepancy in bid validity period between that given in the undertaking pursuant to clause 12.15 and the form of the bid submitted by the bidder, the latter shall be deemed to stand corrected in accordance with the former, and the bidder has to provide for any additional security that is required. 15.2. In exceptional circumstances, prior to expiry of the original time limit, the employer may request the bidders may extend the period of bid validity for a specified additional period. The request and the bidder's response shall be made in writing or by cable. A bidder may refuse the request without forfeiting his bid security. So he can refuse and without forfeiting his bid security. But if you, now that argument, in fact, that argument that they're now raising as not even part of the representations, that it was delayed, is not even part of the original 4 representations that they had cited.
It was there.
Now, second thing, my lords, is that they're referring to, my lords, the conditions of contract. Conditions of contract, my lords, with regard to early warning refers to, my lords, the after the agreement is entered into. It is at the time of execution of the contract. So early warning is what they give to the engineer at the time of execution. That it is not, my lords, with regard to pre-agreement stage. It is not part of the bid document. It is conditions of contract will be shown a standard agreement format. Conditions of contract are all part of the bid document, but that is only for information. Once you enter into an agreement, conditions of contract comes into force. It is condition early warning clause, my lords, is also misplaced application. And my lords, only and page 168, there is one pre-bid meeting option. 9.2 pre-bid meeting. The bidder or his official representative is invited to attend a pre-bid meeting, which will take place at address. My lords have 160. So and so. My lords, here they can give queries in writing. In my representations, in the impugned order, specifically I have stated you have not raised any of these queries in the pre-bid meeting. Therefore, grateful. And my lords, one additional factor I wanted to state.
That order of the single judge direct, if you take some representations later will not come. Whatever is there, 9.2.
Please, my lords. And despite that, we considered it, and we have earlier it was stated that you did not consider the representations. My lords, one more submission under the Surface Act. My lords may kindly note under the rules, 25% got forfeited. In fact, in that case, Shanmugha case, 25% was 3.3 crores and odd. Here, my lords, EMD is a very small amount, my lords, of the entire contract. It is just an earnest money that he gives along with the bid. It is hardly 11 lakhs. So, my lords, even more, there the consequences are stringent, but the principles will apply even more with all force is my respectful submission. Grateful.
Will take some time. Yes. That is also, I've taken that specifically from the RSS. They were standing outside.
Final hearing, 35 and 36 adjourned, seal number 37. B. Raghavendra, Srikanth, Jagdish, Basaraj. 38, SN Sudha.
Yes.
Appearing for the appellants. My lord, in the connected matters, we are yet to file a wakalat for the respondents. We've just received the instructions.
There are two suits, my lord. Actually, one suit was partition, was filed by the appellant in the first matter, my lord, along with his father. My client was the other brother, my lord, the son of the appellant number one. And my client had filed a suit for partition. It came to be decreed. Their contention was there was an earlier partition and all that. Admittedly, sisters are there. They were not parties to the earlier partition as such. So the trial court, after considering the materials on record in the first case, decreed the suit. We had sought for half share in the property. He said because daughters are there, you are not entitled to half share. 1/8 share has been granted. That is the subject matter of the first appeal. Of course, in that first appeal, what had happened, first matter, what had happened, daughters were not made parties. Even though daughters were not made parties, taking into account the fact that daughters are there and they are also members of the family and entitled to equal share, the trial court had granted 1/8 share. The second appeal, which is before your lordship, is filed by the daughters in the trial court. The trial court did not entertain the suit, saying that earlier suit is already decided and the appeal is pending before this honorable court. So in that background, an appeal is filed before this court. Ultimately, my lord, what boils down to in both the cases is whether the case of partition as pleaded by them earlier is proved or not is one aspect. And in view of the fact that admittedly, daughters are not parties to the partition pleaded by them. This is a case where that the judgment passed by the trial court may have to be upheld, holding that they are entitled to equal share. I can understand a scenario where in the earlier partition, it is the case of the appellants in the first appeal that daughters also are given a share and all. They only see like a standard defense, daughters are given some jewelry and all that. Apart from that, no, admittedly, there was no partition. This is the case as such. No doubt what my learned friend is saying is, in their clients who are the LRs of the appellant number 2 in the first appeal, they are respondents in the second appeal. They can take notice and file wakalas. And your lordship may kindly do one thing, kindly fix a date because some applications are pending in the connected appeal also, wherein the impleading application is filed by the daughters to come on record in the first appeal. And some LRs are to have to be brought on record. Those applications also are there. Your lordship may kindly direct the office to put up all the applications so that the matter itself can be decided. Even notices may not be required to be ordered because all the parties are present in both the appeals. That is the only request. In the second
appeal is mine. It's filed by the daughters.
But in second appeal, for LRs of respondent number 4, I can take notice. He has filed an application to bring respondent number 4 here. Respondent number 4 is my client.
Petitions are not there.
Yes, madam.
Petitions are not there.
That's what I'm requesting. I'm saying that all the applications may be directed to be put up so that the matter itself can be decided at the earliest. Yes, madam. Second matter, applications ideo, yella put up. Second matter, applications are pending.
There are applications pending to bring legal heirs of the respondent on record. We shall verify and list all the pending applications.
Kindly a date may be given, madam. It's a very old matter. We in fact moved the matter last occasion.
7-2.
7-2. Much obliged.
Thank you, madam.
Please write the names of the lawyers who will
Yes, madam. Yes, madam.
for us.
We'll be once the matter is listed, my lord, on the same day we can take notice, no issue.
For the
respondent, my lords. Your lordships, may I request for short accommodation, my lords? We were supposed to address our arguments, my lords. Kindly have it on Wednesday, my lords. Wednesday. Much obliged, my lord.
At the request of the Learned Counsel appearing for the respondents list on Wednesday. 9th.
40.
My lord, I appear for respond 16 to 18.
Represent response 1 and 2, now.
2009 appeal.
Yes, 2009.
Comments. Who appears for the appellant?
Neeraj Rajiv Shivam.
We'll start this on another day. There is a chamber matter listed at 4.
Oh, very well.
We can have it on some.
And this will take time, my lord. Because the entire evidence, your lordships will have to appreciate. This is a suit for a specific performance. The agreement for sale has not been produced.
18. Yes.
The lordship may give us the indicated date, my lord.
18-2.
18-2.
18-2.
Is it okay? Very well.
41.
Grateful.
43. 44. 45.
Then for the appellant in 44, it may pass over, my lord. Senior is on his feet before another court hall.
We're afraid we can't accommodate you today. There is a 4 o'clock. Yes,
Yes.
passed over to next week.
Next week.
Exactly.
Interim order may be extended, my lord.
A date may be fixed.
Yes.
47.
48.
Obliged.
ಯಾವ್ದು ಹೇಳಿ ಸರ್? 44 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ 22. ಹಾ.
ಮೇಡಮ್ 47 ಯಾವತ್ತು ಹೋಯ್ತು?
21.
43 ಮೇಡಮ್. ಮೇಡಮ್
43, 20 ಕರ್ದ್ವಿ ಎಲ್ಲಾನು ಸುಮ್ನೆ ನಾಮಕ.
20 ಬೇಡ.
ಹಾ.
19ರಿಂದ 23 ಸಂಖ್ಯೆ ಬೇಡ. ಯಾವ ಇದಕ್ಕಿಂತ ಮೊದಲೇ ಅಥವಾ
24.
24.
ನೀವು ಬೇಗ ಡೇಟ್ ಬರ್ಕೊಂಡು ಕೊಟ್ರೆ ನಾನು ಚೇಂಬರ್ಗೆ ಹೋಗ್ಬೇಕು ಬೇಗ. ಕಟ್ಬಿಟ್ಟು ಇವ್ರಿಗೆ ಎಲ್ಲಾನು ಎಲ್ಲಾದ್ರಲ್ಲೂ ಬೈ ಡಿಫಾಲ್ಟ್ ಹೈಟ್ ಬೇಕಾ? ಎಲ್ಲರೂ ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ತಗೋತಾರೆ. ಹಿಂಗೆ ನಿಮ್ದ್ರಲ್ಲಿ ನಿಮ್ಗೆ ಇದಿಲ್ಲ, ಕೆಲವ್ರಿಗೆ ಹೈಟ್ ಸರಿ ಇದೆ ಅಂತಾರೆ, ನಿಮಗ್ ಬೇಕು ಅಂತೀರಾ, ಅವ್ರಿಗೆ ಕೀಬೋರ್ಡ್ ಚೆನ್ನಾಗಿದೆ ಅಂತಾರೆ. ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ದಿವಸ ನೋಡೋಣ, ಒಳ್ಳೆ ಕಟ್ಕೊಂಡು ಹೋಗ್ತೀವಿ. ಕಾಂಬಿನೇಷನ್ ಚೇಂಜ್ ಆಗಿದೆ. 37 ಇದು 19, 2 ಕೊಡಿ. ನಾನು ಒಬ್ರೊಬ್ರಿಗೆ ಒಂದೊಂದು ಚೇಂಜ್ ಮಾಡ್ಸಕ್ ಆಗತ್ತಾ? ನೀವ್ ಹೇಳಿ. ಅಲ್ಲೂ ಅಲ್ಲ ಇಲ್ಲೂ ಅಲ್ಲ, ಅದು ಅವಾಗಿಂದ ನಾನು ಬರಕ್ಕಿಂತ ಮುಂಚೆಯಿಂದ ಹಂಗೆ ಇದೆ, ಎಲ್ಲ ಹಂಗೆ ನಡೀತಿದೆ. ನಾನು ಅದು ಚೇಂಜ್ ಮಾಡಿಸ್ತಿಲ್ಲ, ಅದಕ್ಕೆ ಕರೆಕ್ಟ್. ನಮಗ್ ಸರಿ ಇದೆ, ಏನ್ ಮಾಡಿಸ್ಬೇಡಿ ಅನ್ನೋರು ಇದಾರಲ್ಲ, ನಾನು ಏನ್ ಮಾಡ್ಲಿ? ಅದಕ್ಕೆ ಸ್ಟೇಟಸ್ ಅಲ್ಲಿ ನಿಂತ್ಕೋತಾರೆ, ಅಲ್ಲಿ ನಿಂತ್ಕೋತಾರೆ, ಹಿಂಗೂ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೋತಾ ಇದಾರೆ. ಇವರು ಪಿ ಎನ್ ಎಲ್ಲ ಇಲ್ಲೇ ನಿಂತ್ಕೊಂಡು ಅದ್ರ ಮೇಲೆ ಇಟ್ಕೊಂಡೆ ತಗೊಳ್ಳೋದು. ಇದ್ರ ಮೇಲೆ
ಜಾರತ್ತೆ ನಾವು ಹೇಳಿದ್ವಿ ಅಂತಾನೆ
ನನಗೆ ಹೇಳಿಲ್ಲ, ಸುಮ್ನಿರಿ.
ನಾನ್ ಕೇಳಿದೆ ಅದ್ ಹೆಂಗಮ್ಮ ತಗೊಳ್ತೀರಾ, ಜಾರ್ತನೆ ಇರುತ್ತೆ ಅಂತ.
ಕೀಬೋರ್ಡ್ ನೀವ್ ಒಬ್ರು ಹೇಳಿದೀನಿ, ಯಾರು ಹೇಳೂ ಇಲ್ಲ. ಹೋಗ್ಲಿ ಬಿಡು, ನೆಕ್ಸ್ಟ್